cases, Lordship. Can it be fixed before vacation, Lordship? No interim is there.
26.
Item number 26.
Is I not received? Okay, right. I heard Mr. B. Chaudhary, the Lord Council, if incorrect is the plan. Also heard Mr. P. Sony, the AP for the state. Case there is still a case that is awaited. Let the matter be fixed on 18 June.
Obliged.
May I please your lordship? I beg to mention item number 10.
Mm.
The matter has been infructuous. The relief we have sought for has been granted.
Item number 10.
Yes, lordship.
You want to withdraw the matter?
Yes, lordship.
No, I'm appearing for response number 1 and 2 and 3 in this case. Their grievance is not non-registration of FIR. That has been registered, his statement has been taken.
Non-registration of the FIR.
FIR.
How it has been registered?
That has been registered.
Okay.
That has been registered.
So they'll let you
Yes,
want to
yes.
withdraw,
Yes,
let them
yes.
withdraw?
Yes, yes.
But your name?
See, go boy.
C. Gogoi, the London Council, appearing for the petition submit that she has instructions to withdraw the incentives. Mr. D. Nath, the learned senior government advocate, is present for the response. State respondent. The case is dismissed on withdrawal.
May it please your worship. Worship, regarding item number 13, my lord, case there is perhaps not available. The petitioners are otherwise on interim matter.
Heard Mr. S. Nawaz, the learned council, appearing to the accused applicant, also heard Mr. D. Swami, learned AP. The state case there is not receiving the instant case. Let the matter be listed on 19th of June.
And interim may be continued.
Interim would also passed earlier, shall confirm till the next date of list.
But I'm praying for item number 40, my lord. Right, don't know.
40.
44 last item.
Hmm.
Right, German, my lord.
So you are appearing for whom?
Brother M. Rahman. Petitioner, my lord.
Sam Rahman, the London Council, appearing for the petitioner. Pays for adjournment of the matter. Let the matter be listed after 2 weeks.
Last month, my lord. July.
After 2 weeks.
That may be fixed, my lord.
Hmm?
That may be fixed, my lord.
After 2 weeks. 4 dates.
May it please your lordship, on behalf of B. N. Gogoi, I beg to mention item number 37. Lordship, my senior is currently out of state, so may kindly.
Mr. So the London Council appearing for the
After 2 weeks.
on behalf of Mr. B. N. Gogoi, the learned conducting council in the incident case. Praise for adjournment of the matter. Let the matter be listed after 3 weeks. 3 weeks.
May I please not? I beg to mention item number 20 from daily list, my lord.
22.
20.
Whatever.
CD was called for, probably CD is not received.
This is Sastic subject.
Let the matter come.
May it please your lordship? I beg to mention item number 14, your lordship. Can you pass over the matter for the day? Senior has some personal difficulties, your lordship.
Your name?
S. Sharma on behalf of M. Chaudhary.
MSS Sharma, the learned council, appearing on behalf of Mr. M. Chaudhary, submits that Mr. Chaudhary is indispensable today. Pays for adjournment of the matter will be listed after 2 weeks.
Lordship, can it be 1 week, after 1 week? Obliged.
May I please, your lordship? Lordship, beg to mention item number 38, lordship, hearing matter where senior is out of station, lordship. So matter may kindly be adjourned for the day, lordship.
MS so the learned council, appearing on behalf of Mr. A. M. Borgi, the senior council, conduct.
Interim is there, lordship. Interim.
Conducting the case, praise for adjournment of the matter as Mr. A. M. Borgi is out of station. Let the matter be listed for 3 weeks. Interim order so passed earlier and continue from the next date of listing.
May I please?
Yes.
May I please? My lord, item number 11. With the consent of the other side here.
11.
Yes, I may be allowed.
Can it be fixed on next Tuesday?
Next
madam?
week.
There's some urgency.
Mr. A. I. Talukdar, the learned council.
Ayatalugda.
Mr. A. Talukdar, the learned council, appearing for the respondent. With the consent of the other side, praise for adjournment of the matter and adjournment of the matter for a week. Fixed up. The matter will be listed after a week.
Well, on 16, well,
After a week.
May it please your lordship. Lordship, I beg to mention item number 12, lordship. Matter may be adjourned for a day. My senior Mr. M. Biswas is unwell today, lordship. My senior Mr. M. Biswas is unwell today, lordship.
Mr. M.S. Soren's the learned counsel. Appearing on behalf of Mr. M. Biswas, the learned counsel conducting the case. Praise for adjournment of the matter as Mr. M. Biswas is not keeping well. Let the matter be listed after a week.
Obliged, lordship.
May I please, Lordship? My lord, this is criminal revision NI Act. It was second revision, that's why it was asked to show citations. And
Which,
since February, it is not.
Which item?
My lord,
Which item?
not I think, I want to mention it.
Mention, you go to the senior bench. Senior bench is there, and all mentions are in the senior bench. Senior bench is there available. You'll have to go there.
Right.
may I please, your lordship? Lordship, allegation is 1032 of BNS, lordship, earlier 302, lordship. FIR in page 9, lordship. Here the informant states that on last night at about 8 p.m. lordship, when his younger brother went out for fishing of the western side of his house, page 9,
I heard Miss, your name?
NH Luster, lordship.
And it's last for the learned council. Can also have Mr. DP Goswami appeal for the state. This is an application under section 483 of BNSS for granting bail to the accused applicant in connection with Align PS KALAIN Align PS case number 35/2026 under section 61(2)/1032 182/109 of BNS 2023. Call for the city, let them at the week.
Lordship, maybe 17 or 18, lordship. He's 55 days today is behind the jail, lordship. 17 or 18, lordship.
302, right?
302, lordship.
So,
Lordship, 55, he is not informed this offense, lordship. In the lordship, kindly see there was a forwarding report, lordship. Indirectly, they are saying indirectly involved. But in the FIR, they are saying they are seeing the miscreant, lordship. Out of grudge, lordship, that village enemies, lordship, they named the prisoner.
and when do you want?
19.
19. Let the matter be listed on 19.
I love it.
Wait, please, lordship, the FIR is at page 10, your lordship. Lordship, page 14, your lordship. FIR is at page 14. Lordship, what had happened? The petitioner herein is an advocate. Now, while in the night time, while he was passing down the Ganeshguri flyover, he had an argument with this scooty rider. And unfortunately, it escalated into a scuffle, lordship. And inadvertently, when he gave a slap, this boy fell down and got injured. The FIR and read,
We'll see the CD.
lordship. Only the grounds of arrest I wanted to point it out, your lordship.
We'll call for the CD. So,
Lordship,
a short list. Your name,
Zizad.
Huh?
Zizad.
Ahmed. Zizad Ahmed, the learned counsel appearing for the case. You can also have Mr. DP Goswami, learned appearing for the state. This is an application under section 483 of BNSS 2023, paying for 20 bail is applicant in connection with dispute PS case number 316/2026. Registered under section 117 in bracket 2 and 109 of BNS 2015. Call for the city, let the matter fixed on 19th.
Lordship, on 16th, your lordship. On 16th, your lordship.
9th June.
Because attempt to murder is prima facie not made out, your lordship. Only
So we'll see.
Previous,
But there are a lot of other matters also there. So we cannot give you accommodate. I mean, we cannot give you priority to others.
May it please your lordship kindly allow it for time being because my senior counsel is in another court.
Who's your senior counsel?
Tisha, Miss Tisha.
Okay, pass over for time being.
Obliged.
No, please, Lordship. Lordship, the non-bailable section is 118. That is, yes, Lordship. Kindly come to the page number 10, the FIR. May I? My involvement is not there, Lordship. May I go to the FIR, Lordship?
This I've seen the FIR. We'll see the CD.
Yes, definitely, Lordship. But thing is that
Mr.
the
A.K. Sharma, the
Lordship, fact behind is that the boy, that name is Sadir Ali, was the accused, the son of this petitioner, Lordship. Police called the petitioner and asked him to produce the boy, the son. When the father failed, that is petitioner failed, he kept him. Police kept him.
allegations are using sharp weapons.
Yes,
I mean, there was some scuffle and like a weapon was used and somebody got previously injured.
but
Like, that is the allegation.
that is
We'll
the
see what is there in the case diary. Then
kindly
we
give
will-
us short
then we'll
details.
consider.
Because I was not in the place of occurrence itself.
Okay, we'll consider that.
That-
Consider. I heard Mr. A.K. Sharma, the learned counsel, appealing for the accused. I also heard Mr. DP Goswami, appealing for the state. This is an application under section 483 of BNSS for granting
No, I think it was
bail,
18.
granting bail for
Short, no.
granting bail as an indicate in connection with Nagaon PS case number 377/2026 under section 126(2), 1182/45 of BNS 202. Call for a civil letter matter will issue on 18th.
The play blood.
This is a non-FIR. Yes, my lord, the fact of the case, my lord,
Huh?
6/5/2025 at night, my lord.
Non-FIR.
Non-FIR. Yes, my lord. There is no any FIR, my lord. On 6/5/2025 at night, my lord, at about 3:40 AM, the police visited the resident of the petitioner, my lord, and searched him, but he was not available at home, my lord.
He was not there at 3 o'clock also in the night.
On that day, he was not at home, my lord.
No, he was not at home at 3 o'clock in the night.
Police visited at 3
Correct. So he was not at home.
at home, yes.
So what was he doing at the time?
He is a cultivator, my lord.
Hmm?
He is a cultivator.
Cultivation 3 o'clock in the night.
No, my lord, he was in the,
What is your apprehension? Why?
because my lord, police visited his.
No, why police visited you?
I don't know, my lord, and not only the house of the petitioner, my lord, his brother-in-law's house also visited, and on minor's son also pick up, my lord. Subsequently, he was, my lord, allowed to go. My lord, I have stated in paragraph 3 of the petition, my lord. Subsequently, the petitioner searched in the PS as well as the PI court, my lord, but no FIR is
So
found.
there is no apprehension. You cooperate with the investigation. You go and
Because without, my lord, whether any FIR is there or not, my lord. So, my lord,
go and
instruction may be called for, my lord.
without any affair, without any particular things, you just come to the court and ask for anticipatory bail. That will not do. You have to show procedures apprehension. There is some material
So-
on the in the air and with in the air and with some vague statements. You
No,
cannot
my lord.
Here and
There
like
is no big
violate
statement,
the-
my lord. One Akir Hussain also pick up, my lord. My lord, I have stated in paragraph 3, my lord. Subsequently, he was allowed to go, my lord, without arrest, my lord. In the evening, my lord. He was picked up at night, my lord, 2 to 2:30 AM. And he was allowed to go, my lord, in the evening, my lord.
From the statement he has made in the paragraph 3, Lordship, no case is
Paragraph-
made out. Yeah, no case is there.
Because, my lord, the police visited the resident of the petitioner, my lord, at night. So there is a apprehension, my lord.
You get a report in this case because there is a statement that police visited his house, his brother-in-law's house, and one person was picked up also and released.
Maybe.
So there may be certain things. So you collect a report, Lordship. Heard Mr.
M. Hussain.
M. Hussain, the learned counsel appearing for the accused applicant, also heard Mr. DP, Mr. DP Goswami, the learned DP speak. Reason application number 6484 BMS. Page granting this to bail to the accused applicant. Accused applicant, full stop. The learned counsel appearing for the accused applicants submits that police has visited his house and his brother-in-law's house. However, the police did not divulge any facts or any connected affair that has been filed against the accused applicant. He's also submitted that in spite of their best effort, we could not find any details of any case registered against him. Taking into account that was a report is it is directed to the concerned police station of concerned officer in charge of Vilasipara police station to submit a report providing the details of any case that is registered against the accused applicant. Later matter will be listed on
19th,
let it be before that.
but 17th. Not.
Twelfth, it will be on 12th of June. If nothing is there, your case will be dismissed.
Okay.
It is a lordship. I'm not here in this state present petitioners, they are not an affair name accused. They're a husband and wife. And just because of, the informant, the accused, my younger brother, some mandatory transaction taken place. In this regard, for our phone, the police has asked us to appear before the investigating authority. So on that apprehension, we have before this court in paragraph 5, 6, and 7, we have stated all the facts. In affair lordship, you'll find 11. And particularly, I like to draw your lordship attention in paragraph, page 16, my lord.
Where is that FIR?
Page 13, my lord. This is again Saddam Hussein Majumdar. He is my younger brother, my lord.
Hmm?
And already in paragraph 16, the accused had assured him to return the bag, return full the amount, and also issue check the whatever amount he informant has paid to the accused person. In paragraph page 16, bottom line, my lord.
You read the FIR first,
Yes.
let us know the facts.
Yes, my lord. I, Subedar Major Jamil Hussain, retired veteran of Indian Army, permanent resident of village Soencho, Hospital Soencho, and my lord, from most respectfully submits this complaint seeking registration of a false information report against Mr. Saddam Hussein Mojumdar, late of Soencho, along with persons associated with him who were actively involved in the handling and operating the financial transaction of IAA traders to current accounts for having executed a deliberate and well-planned course of deception, inducement, representation, and the criminal breach of trust by dishonestly obtaining and wrongfully misappropriating substantial portion of the lifetime retirement corpus savings belonging to me and several other retired Indian Army veterans and contributors, though repeated assurance of repayment, security, and profit sharing, and subsequently avoiding repayment immediately before the agreed settlement deadline, thereby causing grave financial loss and mental hardship, and disclosing the commission of serious cognizable offences of cheating, criminal breach of trust, and conspiracy. It is further respectfully submitted that the entire entrusted corpus amount will transfer strictly on the instruction and represent of Mr. Saddam Hussein Mojumdar into the following bank account number IAA Traders, which are represented by Mr. Saddam Hussein Mojumdar to be the under his ownership Operational Control Financial Authority. These accounts were repeatedly used by Mr. Saddam Hussein Mojumdar and the persons associated with him as the designated receiving channels for the transfer of the said retirement corpus funds of mine and other contributors, and strength of his representation regarding secured deployment and assured repayment liability, which obligations he has subsequently failed to honor, and instead became the untraceable immediately prior to the agreed payment deadline. It is respectfully submitted that the said retirement corpus represented hard-earning savings accumulated.
We'll have to look into CD.
Yes, my lord. We are not the FIR name accused, my lord. I am the husband and wife. That's elder brother and sister-in-law, my lord. Police has twice we have been called over phone. You come and appear before this court. We are ready even with some protection we are good. And if we get a protection, we definitely appear before the authority. I will cooperate with the authority concerned.
See that he heard Mr. Peter.
And we are not the FIR name accused person, my lord. We are just seeking some protection, my lord. We'll appear definitely, my lord. We'll cooperate.
Heard Mr. P. Dekadal and also appearing for the accused applicants, also heard Mr. D. P. Goswami and ATV for the state. Please an application under section 482 of IRB in SSP. Paying for granting PRS bail to the accused applicants in connection with sales of PS case number 331/2026. 26 under section registered under section 316 in bracket 2 stroke 318 bracket 4 stroke 319 bracket 2 61 bracket 2 of BNS. All for the city with the matter fixed on when.
My lord, some protection will be granted. So we are going to appear. We are not an FIR name accused, my lord. Nothing material is against us, my lord. So with the protection, we'll appear, we'll give a statement and cooperate with the authority, my lord.
18th of June.
My lord, in the
We're
meantime,
giving a short date.
my lord, then my lord, we go and we'll appear before the investigating authority, my lord.
Let us see. I mean, there's a huge. I mean, the allegations are very serious.
They serious against the accused person, not even single material against us, my lord.
Then, if you don't have anything, why you have come to the court?
Then, my lord, the police has asked us to appear before the authority.
Go and appear.
Then, if we appear, then we are apprehending, my lord. We might be arrested, my lord, on this in regard, my lord. Twins, no connection, my lord. So, my lord, early date some period, my lord.
18th.
16, my lord. Can you on 16?
16th. 16th.
Is your lordship, it is a regular bail application. What is the story behind lordship? Petitioner, though he was not named affair in the other case lordship, he apprehending his arrest, he filed an application, and after the interim protection, he appeared before the police station. And during his interim bail lordship, on that particular day when he appeared, this particular case has been lost. Put him behind bars. So we are
There was another case also.
On that particular day when he appeared there for a police call to record his statement, on that day itself another affair has been lost and sent him to jail. So my lord, diary may be called at an early date.
Okay, MSP shown the next counsel appearing for the accused applicant, also Mr. D. P. and AP for the state is an application under section 483 of the SSP Playing for granting bail to the accused applicant in connection with Gauhati PS case number 64/2026 under section 61 in bracket 2 stroke 318 bracket 4 stroke 19 bracket 2 stroke 351 bracket 2 of BNS 2023 full stop call for the CD. Later matter fixed on
17/6.
17/6.
I'm deeply appealing.
Second bill application ଅଛି. This was raised under NPS Act also. The rejection order is additional affidavit ଅଛି. $286 gram was contraband was recovered ଅଛି. To tell as now to do about 5 witnesses was like cross-examined ଅଛି. Out of 8 witnesses ଅଛି. Here 338 days behind the bar ଅଛି.
Where is the earlier rejection order?
Additional affidavit ଅଛି. Page 70.
Please.
70 budget. And observation is paragraph 11 logic. 74. Yes.
What is your ground now?
What is it? 338 days already
Commercial quantity.
commercial quantity logic.
What is the stage now?
5 witnesses examined, Lordship.
Huh?
5 witnesses already examined out of 8. If Lordship kindly sees the Lordship's rejection order, paragraph number 11, Lordship will kindly see. Last part, Lordship, paragraph number 11. Further, the issue could be adjudicated during the trial. Lastly, as seen from the records, the trial is proceeding in a right speed, and the trial is expected to be completed in a reasonable time, as 2 out of 8 witnesses have already been examined before the trial court. So there is no question of inordinate delay. This was passed in the month of February, Lordship. And now today we are in June.
So five witnesses out of eight
Yes.
already.
Already examined. And so far, I am concerned, Lordship, as per the records, 26/5/26 was fixed, last date. And what happened on that day, that is not clear from the LCR, Lordship. So probably, Lordship, it is at the fake end of the trial, Lordship. And they will have to satisfy section 37, Lordship. There is no inordinate delay, there is no procedural anything, Lordship. And Lordship,
It's only counted as 338 days already. But any
there is not be a grounds. Commercial quantity. Section 37 will come with.
And it is going in a rights, I mean, as we have observed earlier also, already
Yes.
if witnesses have been examined.
So you kindly see the charges were framed on 10/12/25.
10.
12/25. So Lordship, within 6 months, 5 witnesses, by the end of this, we are Lordship probably will be finished.
Your name?
Iboran.
No ground, not now, you have to wait. Heard Mr. P. Boran, learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, and APP for the state. This is the application filed under section 483 of BNS 2023. Praying for granting bail to the accused applicant in connection with landing PS case number 94/2025 under section 118 1 in bracket 1 stroke 121 bracket 1 stroke 109 of BNS 2023. Grade with section 21C stroke 27A stroke 29 of the case second raised against the accused applicant. 2 other accused persons pending in the court of the law, special Judge Vijay, as special MBBS case number 580/2025. The case relates to recovery of 284.64 grams of illicit narcotics contraband, that is heroin from the vehicle driven by the vehicle traveling by from the vehicle in which the accused applicant and other two persons were traveling. Stop. After receipt of the FIR, police registered Lambdin PS case number 94/2025 from the aforementioned sections against the three accused persons, including the accused applicant. After completion of the investigation, police filed a charge sheet number 122/2025 with a 39/2025 against the accused persons under sections 118 in bracket 1 stroke 121 bracket 1 stroke 109 bracket 1 of BNS 2023 read with section 21 in bracket C stroke 27 bracket A stroke 29 of any case at 1985. The petitioner has the accused applicant has approached this court on an earlier occasion also by filing the bail application number 3571/2025, which was rejected by this court on 17/2026. With the following observations. Petitioner given. This court did not find any infirmity with the service of notices under section 57 and 48 of the NSS while arresting the accused applicant. Materials available before this court, aforesaid do not make out any case of recovery of bag containing suspected heroin from a different place than the alleged vehicle involved. Also, the variance of weight would not make much of a difference as both the weights go on to make a total weight more than commercial quantity. Further, the issue would be adjudicated during the trial. Lastly, as seen on the records, the trial is proceeding in a right speed and trial is expected to be completed in a reasonable time as 2 out of 8 witnesses have already been examined before the trial court. Therefore, there is no case made out for inordinate delay in trial in the instant case. Court is incomplete. That the learned counsel appearing for the accused applicant submits that the accused applicant is behind the bars for how many days?
338 days.
For more than 330 days,
38 days.
38, more than 38 days, and takes into account his long custodial detention. This court should consider his prayer for bail at this stage. The PCR in the instant case has been received and the same is produced by this court. Mr. B. Sharma, the learned EVP for the state submits that the trial is going on a reasonable speed and already 5 out of 8 witnesses have been examined. This means that at this stage, The accused applicant should not be granted bail by this court. Full stop. This court, after hearing the parties as well as in the account of this court, is of the opinion that the trial is proceeding in the right direction and in a reasonable speed. Reasonable speed. Full stop. It is seen that that the charges were framed on 10/12/2025 and within the last 5 months or so, already 5 witnesses have been examined. So taking into account the offense involved and quantity recovered, quantity of narcotics recovered, as well as the status of the trial, this court is not inclined to grant any bail to the accused applicant as this case. Accordingly, the instant bail application is rejected.
Wait, please, your lordship. No, third application, lordship. No, the third application, lordship.
What?
Third application, this third application. Lordship.
Third application.
Lordship. Lordship, NDPS commercial quantity charge sheeted case, lordship. NDPS commercial quantity, lordship, charge sheeted case.
What is the status now? Is
Evidence is
Records, also I have seen, the records are the records of the court below are not before the lordship, only the charge sheet copy is there. The CR lordship was called for, the order sheet and witness examined, that is not in the records.
Additional is to Lordship, in this case, lordship, I am on the ground of fundamental rights violation, lordship. That is, I have been produced beyond 24 hours, lordship. I am not been produced within 24 hours.
there's nothing in the record.
Yes, again, the records has to be given.
Heard Mr.
Yes, Sushan.
So the learned counsel appearing for the accused applicant also heard Mr. B. Sharma, the learned appearing for the state. So this year in the instant case, scan copies of the TCR were called for, and the same and some records have been received. We seen the records is incomplete. It's incomplete stuff. Registry sent a reminder. Registry to send a request for scan copies of the whole TCF. Whole TCF. So let the matter be listed after 2 weeks.
You can finally reflect deposition of witnesses also.
Especially the deposition of witness.
Date may be fixed, lordship.
Especially the deposition of witnesses. 23rd of June.
Lordship.
Let the matter
Obvious.
be listed on 23rd of
17 lordship, charge sheet has been late.
There is an interim order now. And petitioner already appeared and referred to Mr. Clinton.
Heard Mr. M. Ahmed, the learned counsel appearing for the case of Mr. Mr. B. Sharma, the learned ABE for the state. This is an application file number 6450 of PNSS 2023 for paying for bail to the accused applicants in connection with Ishwanath Chalu, yes, is under the section 223 to 61 to please get 5 of BNS. Full stop. The landed Mr. B. Sharma, the landed PPP has submitted that charge sheet in the instant case has already been filed by charge sheet number
75/26 dated 26/5/26.
Mr. E. Mr. E. Mohammed. Mr. E. Mohammed. In view of the filing of the charge sheet, he may be allowed to vote his wherein the charge sheet has been filed for proper relief. Taking into account the person. The application is closed with the direction to the accused applicants to closed with the liberty the accused applicants to approach the jurisdiction for appropriate for any appropriate relief if so advised. Till his appearance, the entry order so fast earlier of 8/12/26 of this then every application is this then be a bail application is we go and appear to
Publish. 18 lordship CD has not been received.
CD is awaited. Let the matter be listed. After 2 weeks.
My lord, here in this case, my lord, 56 days already behind the bar, my lord. And the matter is that, my lord, one, I had a relationship with that girl, my lord, and thereafter we fled.
60 days, this thing.
One section is, my lord, 7 years, and other one is 10 years.
90.
142 and
90 days.
87, total 2 sections.
See, let us see the CD. We wait for this.
My lord, girl is already recovered. A statement has been recorded. It is in the.
Let's wait for the CD. After 2 weeks.
Right, lord.
As on today, I'm behind the bus since 46 days, Lordship. I was arrested in connection with Gorpata PS case number 132/26 under section 612, 3184, 1114, and 35 of the NS code. This is the sitting case, Lordship, of gold, to fake gold, Lordship. Smuggling of gold, Lordship. FIR in case number 15, Lordship. in FIR Lordship. First, I want to read out the relevant para Lordship. That is the second para Lordship. In the second para Lordship, from the last side Lordship. To apprehend both the suspected persons during search, two number of mobile handsets were recovered from their possession of Abdul Malik and one number of handsets was recovered from the possession of Baharul Islam. No other physical material was recovered from their possession, and also we have searched the house of Abdul Malik. After coming back to police station, interrogation was done, but nothing adverse was found against Baharul Islam. So I let him go on his own as he is an adult person, and also given Jimma of on number of mobile handset which belongs to Baharul Islam. By going through the mobile phones of Abdul Malik, it is learned that he used to deal with illegal gold and also make hawala transaction. Lordship, in this case, Lordship, dated 23/4/2026, this is GD&T Lordship, and FIR dated 24/4 Lordship. I was apprehended on 23 Lordship. And Lordship, I have been produced on 25 Lordship. That is beyond 24 hours Lordship. That is clear from the FIR and the forwarding Lordship. And also Lordship, Caesar list in page number 33 Lordship. The Caesar list, yeah, date and time of Caesar 23/4/2026 at 11:25 p.m. I should be produced, I have to be produced before 11:25 p.m. on 24 Lordship, but I have been produced on 25 Lordship. And which is a violation of fundamental rights Lordship. And in this regard, I want to refer a judgment by the Honorable Supreme Court Lordship. Along with the order passed by coordinate bench of this Honorable Court Lordship.
What I was saying, when was the arrest happened?
Arrest happened, Lordship. That is detained. I have been detained, Lordship. That is apprehended on
When?
23 Lordship, on 23, but I am produced on 25.
How can you say 23rd you were detained?
This Lordship, that is one person, Baharul Islam has been let him go, Lordship. That here in this that just I have read, Lordship. That is so I let him go on his own as he is an adult person on 23rd Lordship. And
Where is the time that when he was arrested? This file was filed on
arrest date and time of arrest, that is on forwarding Lordship in page number 17. It will show Lordship. That is
17 where
in the
time of place of arrest.
Right.
24/4 at 4 p.m.
4 p.m. Lordship. But our Honorable Supreme Court says, Lordship, in the judgment of
Okay, so then what happened? 24/4/2026, you have been arrested.
yes, as per forwarding and notice, Lordship. But as per FIR, Lordship,
He produced when?
produced on 25 Lordship. But
Then?
as per FIR, Lordship, I have been apprehended on 23rd.
No, FIR doesn't say any time. FIR was filed on 24 only.
And also Caesar list is there, Lordship. As per Caesar list
was filed on 24.
Lordship, but as per Caesar list also I have been apprehended because after seizuring, the police person will not allowed to go me, Lordship.
This issue was raised before the concerned court below also, Lordship. That court has also rejected the same ground, Lordship, at page 22. Lordship, the court below has stated that he was arrested on 24/4/25.
That is the formalities, Lordship. Time of arrest has been given by the police personnel. The seizure list met. No police will allow me to go out, Lordship. And also clearly said by the Honorable Supreme Court, Lordship.
Arrest is on 24.
Arrest is 24.
At 4 p.m. and all the documents is arrest memo also says so.
Yes, Lordship, that is 24, Lordship.
Everywhere is.
Yes, Lordship. That's all, Lordship. I just want to read out, Lordship, the relevant para in the judgment Director of Enforcement versus Subhash Sharma, Lordship. That are not just a minute, Lordship.
These two grounds, twice they took this ground before the concerned court, Lordship, and both times these grounds were rejected.
Why I have taken this ground, Lordship, just a moment, Lordship. That is in para 6, Lordship. This argument cannot be accepted. Admitted the LOC was issued at the instance of the applicant Directorate of Enforcement. By executing the LOC, the Bureau of Immigration detained the respondent at LG Airport from 4 March 2022 on behalf of the applicant. The finding of fact recorded in paragraph 10 is that undisputedly the physical custody of the respondent was taken over by the applicant from the Bureau of Immigration at 11 hours on 5th March 2022. Thereafter, at 1:15 hours on 6th March 2022, an arrest memo was prepared. That is next day, Lordship, by ED at Raipur. He was produced before the court at 3 p.m. on 6th March 2024. The perusal of the arrest order Annex P1 shows that the type order was kept ready. The date and time of arrest were kept blank, which appeared to have been filled in by hand. Admitted the respondent was not produced before the nearest learned magistrate within 24 hours from the 11 hours, Lordship. That is 11 a.m. on 5th March. AM on 5th March 2020. Therefore, the arrest of the respondent is rendered completely illegal as a result of the violation of the clause 2 of the Article 22 of the Constitution of India. Thus, the continuation of the respondent in custody without producing him before the nearest magistrate within the stipulated time of 24 hours is completely illegal and it infringes fundamental rights under clause 2 of the Constitution of Article 22 of the Constitution of India. Therefore, his arrest gets vitiated on completion of 24 hours in custody. Since there is a violation of Article 22 of the Constitution, even his fundamental rights to liberty granted under Article 21 has been violated. The arrest time was shown 3 p.m. on 6 March 2024, and in the same day, in that case, has been produced. But he has been detained. Physical custody was taken at 11 hours on 5 March. And also on manipulation made by police personnel also is there, Lordship. In page number 37, Caesar list, Lordship. I have been produced on 25, but Caesar missed another Caesar list made on 26, Lordship.
Yes, later on they went to your place and searched your house, then got this.
Same things, Lordship, same mobile phones, Lordship.
Yes, mobile phones.
Mobile phones. In the page number 33, same things, Lordship. One count had already been seized and again showing on 26, Lordship. That is manipulation, Lordship. Just to cut in the 24 hours. And after forwarding, Lordship, the mobile phones has been seized. No police allow to keep the mobile phones with me at the time of forwarding, Lordship. But after forwarding the next day, same thing, Lordship. In page number 33, time given in the seizure list, on that basis, the Honorable Coordinate Bench already allowed, Lordship, the petition to go on bail, Lordship. That is, I have submitted, Lordship, the Coordinate Bench order, Lordship. The time is calculated from apprehension.
Why two seizure lists?
First seizure list, Lordship. 33. Produced by Abdul Malik. This is this mobile phone. Thereafter,
One black color Samsung Galaxy.
yes. And thereafter, Lordship,
A22,
from his home.
and witnesses are Saiful Islam and Sultan Alam.
Sultan Alam, yes.
And here the witnesses are different. One is same. Saiful
Yes.
Islam is there. Quddus Ali has.
Yes. Next seizure, Lordship, page 35. This is from his own been laid and shown by Abdul Malik. This is again Samsung phone.
Then one Samsung basic phone
Yes.
and one Samsung Galaxy 820. The same mobile phones.
Okay. This is Galaxy A22 mobile.
Same mobile phones.
How are you saying that these are the same mobile phones?
Probably not same, Lordship.
Same Lordship.
How you're saying?
This Lordship. That is in page number 33, one black color Samsung Galaxy A22 mobile, model number same. And so
Here it is. Where is the model number?
Galaxy A22, same model Lordship.
Where?
In 37.
And where? Galaxy A22, maybe there are thousands of pieces.
Yes.
Does it mean the same mobile phone?
But Lordship,
The places are different. One is from the seizure was one seizure. The initial seizure was from the Barpeta police station campus itself.
Lordship.
And the other one is from his house.
That is
Abdul Malik kept on the bed of the house of Abdul Malik.
And second one is one Samsung.
On 26/4/2026 at 2:45 p.m.
Lordship.
How can you say that these are the same mobile phones? Same mobile phones have to, I mean, there may be A22 model, not many models. How will you say that this is same model, same phones? Because the place of seizure are different.
Yes, Lordship.
Is different. No, that is as per the record.
As per the record, Lordship.
As per the record, the time is different, place is different. Difference is there. Only thing is that only because that one mobile phone is 822 model, that cannot be said that it is the same model.
And second one is the one Samsung basic phone. That is the keypad mobile phone. And also in page number 33, showing that is one blue color Samsung keypad mobile phone.
Maybe.
Yes, Lordship. Both.
Or where it says a blue color? Where does it say? In 37, where does it say blue color? Where is that?
It can be presumed, Lordship, that is the same mobile.
Presumed. I mean, there are so many mobile phones. He may be having 10 keypad mobile phones. On that presumption, how the presumption will go?
So, time, date and time may be considered in the page 33, Lordship, seizure list. That can be considered.
That will be considered. Nowhere it is said that he has been arrested.
To consider the 24 hours, Lordship. I have not been police within 24 hours. That can be considered, Lordship.
Why it will be considered that he is arrested on at that time?
Apprehended, Lordship, not arrested.
Then
as per only the Honorable Supreme Court saying that the time of arrest should not be calculated, but time should be calculated from the apprehended, Lordship.
No, it doesn't say so, Lordship. It says, Lordship, when law comes into force and he is placed under the custody of law. That is, Lordship, one case is the 19.
Custody was taken over, Lordship.
Physical hold of the arresting authority.
Custody has been taken over.
As per seizure list, Lordship.
How? Seizure list means he's been arrested. He has been taken, he's been detained.
Lordship, after made seizure list, no one will allow me to go out, Lordship.
They will
That
take you,
cannot be presumed,
take you around to
Yes.
recover other things maybe.
Yes, Lordship, and
But only after completion of the
Inquiry, yes.
initial inquiry, then they will arrest you.
Yes. If something is found.
If something is found against you, why they will, otherwise they will arrest.
so arrest time is given that in FIR, Lordship, in page number 15, Lordship, from the beginning, Lordship. That Lordship, from the beginning, Lordship. That is, with due respect, I have the honor to inform you that on 23/4/2026 at 1:54 AM, information was received by OC Borpata.
So you were not
Information was.
found initially. The police has to go to your place. Then you were riding a vehicle, right? Then you wanted to, and you were just about to enter your house, then police came.
Yes.
Then police recovered certain things from you. Then police maybe police took around, I don't know what has happened after that. Then they arrested you on 24th at 4 PM.
No, so these grounds were taken twice before the concerned court, and both times it was rejected.
No,
It's-
but a rejection, that doesn't mean that, like,
No,
I mean,
I understand.
has to be- they have rejected, that's a different.
No. Lordship, they have verified it. That's what I'm pointing out. The trial court is,
There has to be some clarity in this.
yes. At page 27 also, Lordship will kindly see.
Yes, allegation, Lordship. After seizure list, no one will allow me to go out, Lordship. This is my submission, Lordship.
The offense is also very serious, mister. Correct? Hawala, 3 crore, 4 crore, 5 crore, you are doing
Lordship, that is maybe the
business.
Lord-
What do you do?
miscellaneous business,
No,
Lordship.
but what kind of miscellaneous business?
Lordship, direct instruction is not there, but here's.
No, what kind of business you do?
Professional business.
How much of money? 3 crore, 4 crore, Hawala you do?
That's all.
You write down. Heard Mr. So and so, M. Islam, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. Is an application under section 43 of EMSS 2023. Praying for grant of bail to the accused applicant in connection with Borpata police case number 132/2026 under section 61(2)/3184 of 1114/353 of BNS 20. An FIR was lodged on 24/4/2026 by the complainant, namely SI Pranav Borua of Borpata Police Station, stating that on 23/4/2026 at 1:54 PM, an information was received by Borpata PS, OC Borpata PS, from OC Kalkasya PS, that one person, namely Umar Ali, was detained at New Bongaigaon railway station by GRP, where 5 biscuit-shaped gold bar pieces of suspected gold were recovered, weighing 583 grams. Semicolon, that the gold was seized from the position, and accordingly seized from the position, semicolon. Accordingly, OC Algasia PS proceeded to the house of Umar Ali and searched his house. During the search, the Umar Ali's wife disclosed that illegal activities involving gold smuggling and fraudulent transactions were being carried out by one Abdul Malik semicolon that accordingly the OC Borpeta PS informed the matter to the additional SP in bracket crime Borpeta over the phone, and on being instructed on being instructed that the complainant along with the police staff proceeded to the house of Abdul Malik, and before reaching the village, the complainant called the village admin also. Semicolon, that after reaching the house of the Abdul Malik, one car was spotted and two persons were found inside. Semicolon, that on being asked, they revealed their names as Abdul Malik and Baharul Islam Khan. That semicolon, that the complainant apprehended both during the search, two mobile headsets from Abdul Malik and one mobile handset from Baharul Islam Khan were recovered. That the house of Abdul Malik was also searched. Having found no material against the aforesaid Baharul Islam, he was released. That on examination of the mobile phones of Abdul Malik, it was learned that he used to deal in illegal gold and also carried out foul of injections. After the receipt of the FIR, the police registered the police station case number 132 of 2026 under section 1661 stroke 318 bracket 4 stroke 111 bracket 4 stroke 3 bracket 5 of BNS and BNS 2023. The learned counsel preparing for the accused applicants, which that submits that though the accused applicant was arrested on 23/4/2026 at 11:25 p.m. He was produced before the learned magistrate on 25/4/2026, which is beyond 24 hours, and therefore the accused applicant has a right to be enlarged on bail for violation of his fundamental rights guaranteed under Article 22(1) of the Constitution. The TCR in the instant case has already been produced for this court and the same is perused. On perusal of the PCR, this court has found that the accused applicant was arrested on 24/2026 at 4 p.m. 4 p.m. and at that and while arresting him, an arrest memo was prepared. Arrest memo was prepared, which shows the date and time of arrest as 24/4/2026 at 4 p.m. Section 47 and 48 notices 47 notices under section 47 and 48 of the BNSS are also available in the record, which also confirms that the accused applicant was arrested at 4 p.m. 24/4/2026.
Lordship, sorry for interruption, Lordship. Just forwarding, Lordship, just on timing, Lordship, that is timing. In page number 17, Lordship. The brief of the case, Lordship. 1/24/2026 at 12:46 a.m. The FIR has been lost. And in the FIR itself saying that we apprehended the accused persons. That is at least prior to 12:46 a.m. in the morning on 24/4/2026. And it will be 24 hours will be completed at 12:46 a.m.
It was lost when?
Lordship,
24.
Lordship, 124.
24/4/2026
At 12:46 a.m. in the morning, Lordship.
12:46 a.m. in the night.
In the Lordship, that night, Lordship, but 124 in the early morning.
It cannot be 12:46. It cannot be AM. 12:46 has to be PM otherwise. This 12:46 AM, the night
Yes, Lordship.
of 24th.
Yes, Lordship. This is AM, Lordship.
Hmm.
And it will be completed 24 hours on 12:46 a.m. on 25, Lordship.
AM means night.
In the midnight, Lordship.
Midnight.
I have been produced after that, Lordship.
Midnight of what? Midnight of 25th.
Yes, Lordship. That is
You are produced when?
that is after 12 on 24, Lordship.
You have been you are produced on
25.
25/4/2026.
Lordship.
What time?
At least after 10:30, Lordship.
At least after 10:30.
Lordship. But
So it is within 24 hours.
no, Lordship.
Why?
Because the AM starts from in the midnight 12, Lordship. That is on 25 in the midnight.
So midnight 20 midnight 12:46
Yes, Lordship.
to noon 12:46, 12 hours.
Yes, Lordship. That is on 20.
From midnight
Yes,
to noon in the next day, it's 12 hours.
yes,
Then
Lordship.
24 hours will be completed when? Only on 26th.
No, Lordship.
26th.
No, Lordship. As per Lordship, brief of the case on 24/4/2026 at 12:46 a.m. Lordship.
12:46 AM midnight.
Yes, Lordship. Midnight. That means Lordship.
That means that then 24 hours will be completed when? 25th midnight only.
Yes, midnight. I'm saying Lordship.
Then
Lordship. If I presume that is 10 a.m. in the morning.
morning, the
Yes,
within
10
the
a.m. But before that 10 a.m. that is 12:46 a.m. Lordship. Comes from Lordship.
what you're saying?
No, Lordship.
Midnight to midnight, it will be 24 hours.
Yes, Lordship. That is
On 24/4/2026 midnight
yes,
to
Lordship.
25/4 to this 25/4/2026 midnight, it will be 24 hours. So
Midnight.
you were produced in the morning of
Yes,
what,
Lordship.
5th.
Yes, midnight will be completed at 12:46. But
12:46 midnight night. But you have been produced in the morning
after
itself.
that, Lordship. That is that time.
You
after
have
that
produced
time.
when?
After that
That is at least 10:30, after 10:30.
When you tell me when, at what time you have been produced?
At least after 10:30, Lordship.
After 10:30?
Yes, Lordship.
So 24 will be completed only in the midnight.
Yes,
Midnight of 20.
that is not
25.
Lordship. That will be 26, Lordship. I'm saying, Lordship, from 24 to 25 midnight, it will be 24 hours, Lordship.
24th midnight to 25 midnight, it will be what?
Lordship, I'll clear, Lordship. 124, just please, I'm sure, Lordship. 11:30 p.m. 11:30 p.m. is 23rd, Lordship. And after that, 11:30, then 12, immediate after 12, that will be AM, Lordship.
That will be what?
After 12, in the midnight, 123, Lordship.
After 12 midnight will not be PM, that will be AM.
Yes, Lordship, that's what I'm saying.
That will be AM.
Yes.
So from AM 12:46 AM to 12:46 PM,
Lordship.
that will be 12 hours.
Yes, Lordship.
And after that, another 12 hours, it will be midnight.
Yes, Lordship.
Then it will be on 26th.
No, Lordship.
No,
Lordship,
don't teach
maybe I'm wrong.
these things. You are confusing unnecessarily.
Lordship, just to,
You are confusing unnecessarily. Don't speak much. We
no,
have
Lordship,
learned.
I'm not confusing, Lordship.
We learned it. You know, I know how to do the calculation. Don't need to tell me.
Lordship, I'm not saying that Lordship is
What is been written? In the record, which reveals that the accused person was arrested at 4 p.m. on 24/4/2026. It is also seen from the forwarding report dated 25/4/2026 that the accused applicant was produced before the CJM from Barpeta on 25/4/2026 on therefore this court is of the considered opinion that there is no infirmity in production of the accused applicant before the learning CJM in the incident case. It is also seen from the reports that While arresting the accused applicant, there was no infirmities as notice under section 36, section 47 and 48 have been duly complied with by the arresting authority at the time of arrest of the accused applicant. Taking into account all the aforesaid aspects of the matter, this court is not inclined to grant relief to the accused applicant at this stage. In view of the aforesaid, the instant bail application is rejected.
Okay.
CD2 is accepted. Stop back and follow because the direction of the case that we can closed with the liberty, the case applicant approach that the jurisdiction in court.
21.
Jurisdiction in court
15 days time will be granted.
within a period of 15 days, within a period of 15 days. It's till that till his appearance, the interim orders were passed earlier on 25/2026 shall continue. It's in the aforesaid terms, instead of the instant bail application is disposed of.
Obliged.
Lordship. Lordship, affair placed in Lordship. Petitioner behind the bus since 35 days as under Lordship. Since 35 days behind the bus Lordship. This is 64 one Lordship.
I'm just placing the statement and nothing else is required, Lordship. Also, the petitioner is a pharmacist.
Consider the detention of this period. Lordship 5/5/26.
Nice. The whole CD is there.
Yes, yes, Lordship. Lordship will also peruse his statement, Lordship. He is a pharmacist, Lordship. And how can he examine a girl, Lordship? And in this manner, Lordship.
Pardon, sir. I'm saying. Counsel is paying for the accused applicant also by the Sharma, the deputy for the state. is an application under section 43 of BNS 2023 praying for granting bail to the accused applicant in connection with Voco PS case number 106/2026 under section 64 bracket 1 of BNS 2023. Blood only counsel being for the accused applicant submits that the accused applicant is no way connected to the affair. Connected to the offense that has been alleged in the affair. If it affair dated 4/5/2026, wherein the allegation has been made that the informant was wrongfully touched by the accused applicant under pretext of putting some ointment as she was having a problem of pimples. Which he submits, the learned counsel submits that the accused applicant is behind the bars for last 35 days. Therefore, taking into account his detention, long detention, the accused applicant could be granted bail. CV in the instant case has been produced before this court, and the same is produced by this court. Of the perusal of the CD having found sufficient assignment material against the accused applicant, this court is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant bail application is rejected.
22 lordship charge sheet has been submitted.
But do you go? Mr. Biswas, you go there?
Yes, madam. Madam, I am behind the bar.
You go there and approach.
That's the beginning.
Proceed has been always. I heard Mr. S.C. Biswas, the learned counsel, against the accused applicant, also heard Mr. B. Sharma, the APP for the state. This is an application under section 450 as ENSS 2023 for granting for grant of bail to the accused applicant in connection with all women PS case number 18/2026 registered under section 69/81/115 in bracket 2/131/251 in bracket 3 of BNS. Mr. B. Sharma, the learned APP submits that a charge sheet has already been filed less than case by charge sheet number
10/26 dated 29/5/26.
Before the jurisdictional court. In view of the aforesaid, the instant bail application is closed with the liberty to the accused applicant to approach the jurisdictional court for appropriate relief if so advised. In view of the aforesaid, direction, means that the instant bail application is closed on this point.
CD not received, lordship.
His diary was called for.
Not
Today is 44 days, my lord, he is in custody. 44 days, I don't know whether his custodial detention is required at this stage, because it's a matter of suicide, and apparently it appears there may not be any suicide note in this case. Friday. I am asking him whether he can get it on Friday. Because this is, he is in custody, my lord.
Monday, lordship.
Monday will be difficult. No, Friday, no interfere. Otherwise, I would have some judgment. I would have in place, but at least case diary, let him place the case diary on Friday. This Friday, man. Friday.
The council assisted by council. Submits with the case that is the extent case. See. Let them be listed on set Friday. On 12. On 12, Mr. Das.
Yes. 12.
We have 44 days now today. I think that.
Let them.
Please look into the case diary. So I found that I'm told that there is no suicide note. There are judgment of the Supreme Court also. I have found about 4 or 5 judgments in antecedent debate also. But here is not a case of, it is a case of, my lord, 439, means whatever new section now. And there is one judgment of this court, Jiten Datta's case, my lord, Jitu Datta's case. I'll cite, let it take.
Let him bring the city.
Yes.
24 Lordship, the petitioner shall on interim and CD has not been updated, Lordship. Their statements are not in the case diary. So a date may be fixed, Lordship, to produce the case.
Received the same is not found. Is some published. Where is allowed. Is there when?
22 or 23?
Let the matter be listed on 2023.
Here also, Lordship, the petitioner is on interim. CD has not been received.
Earlier to say you write interim orders. CD not received.
Not received.
CD not received in instant case. Let the matter be listed on 24th. 24th of June.
24th of June.
There's interim order so passed earlier, shall continue till the next letter is.
CD received, Lordship.
May I please, your lordship. My lord, here in this case, in a particular citation, the petitioner had to approach this honorable court. My lord, in fact, my lord, the accused, petition number 1, he lost a FIR dated 15/4/2026, lawsuit will find at page 13. Page 13. He lost an FIR, but police is, instead of registering this case, he has been charged, my lord. And that is the reason, my lord, he is approaching this honorable court, my lord. Here, my lord, the accused, in this case, the accused number 1, page 13, my lord.
Mizanur Rahman has filed an.
Yes, my lord. Yes, my lord. The accused number 1 is Shahnaz Begum. He is the wife of the accused petitioner. And there was a sole relationship in between the husband and wife. This accused number 1 is residing with her parents. A maintenance case was filed. And in that maintenance case, compromise was there. There has been court order directing the accused petitioner to pay 1,80,000 as an one-time alimony and a maintenance of rupees 2,000 to the son. That he has paid. And thereafter, his house is vandalized. And therefore, he lost this case, my lord. And the police is coming to arrest them and not disclosing what is the case. That is the problem, my lord.
So after this filing of the FIR, what happened?
My lord, after filing of this case, police is coming to their house to arrest them, my lord. I'm coming to their house, search them to arrest, my lord. Therefore, my lord, they are apprehended to be arrested. But police is not disclosing what is the case number.
Arrest whom? Arrest
the, my lord, the informant in this case, my lord. Informant and his family member.
Why? Why is so? How you are saying so?
My lord, police is coming to their house. I have stated, my lord, in petition in paragraph 4 and 5 also. The police not disclosing whether the case is registered or not. That is not disclosed, and they're only saying that some cases against them. What is the case number? Not disclosing, and not taking any action against the accused persons against whom he has filed the case.
But what is the bail order?
My lord, this honorable court call for the records, and there is some interim petition not to take any coercive measure.
Lordship, may I clarify, Lordship?
Abdus Salam is who?
My lord,
Abdus Salam,
Abdus,
yeah, that's Quade.
my lord,
Page 16.
page 16, my lord. Yes, my lord, it's another case. Another similar case, my lord. Not related to this is only by because this honorable court in a situation similar situation granted interim protection that we have relied on.
Okay, now you are saying that like after filing of the FIR, nothing has been done by the police against those
Yes, my
who
lord.
have been named in the
Yes.
FIR.
Yes, my
But
lord.
police is instead of that, police is searching you.
Searching us to arrest.
What is that? Please?
Lordship, what has happened? He is the father, informant is the mother, and there is a minor son, Lordship. No doubt, Lordship, there is a family case going on. That's a different issue. Here, Lordship, the mother has lodged an FIR, Lordship, that the father took away the son and tried to kill him. He threw the son into a pond. And here, Lordship, the statement of the minor victim may kindly be seen by your Lordship. There is one eyewitness. 9 years old boy, Lordship.
My lord. Huh? So case registered in summary
109.
109. Nalan. 109 of 2026. Full case. Two Thana.
আচ্ছা, দেখাই দিম মই।
Serious allegations, Mr.
Next page, Lordship, will see the eyewitness, Lordship. I flag mark the green flag. Eyewitness, Lordship. He found a boy shivering with cold, Lordship, with mud all over. He took him to his house and cleaned him up, Lordship. This is the eyewitness. And Lordship, I'm sorry to say, Lordship, because this on the apprehension they come, Lordship, they do not know any FIR has been lodged. And then they obtain no coercive action order. And thereafter they appear in such a serious case, Lordship. He is the father. That is the modus operandi now, Lordship. They do not know whether any FIR has been filed. Can it be possible, Lordship?
My lord, that was the stand taken by the accused petitioners. My lord, may not be correct, but the police at least disclose the case number if any lost against him.
There are sufficient materials, Mr.
Well,
Heard Mr. A.R. Sigdal, the learned counsel for the accused, also heard Mr. B. Sharma, the learned APP for the state.
নিজের লড়াই ফাঁসি পালাবো এটা তো বিশ্বাস করি এই কথা তো
নিজের স্থলে গ্রেড করা কেস হয় দেখা পাম গাঁও কথা নহয়
This is an application under section 42 BNSS 202 for ranking clearance bill.
ইনভিজিবল অ্যাকাউন্ট অফ কনজার্ভেটর
Exactly.
Under an unregistered corporate police station case. Also. Mr. C. Mr. Yes, that the law accounts. I think that there was a dispute between the prisoner number one and his wife. And according to one maintenance case is also. Prisoner number one is in the maintenance. But in spite of that, along with some others came to the residence. And also vandalized. There, an account was lost in the consent registration by the accused applicant, but the same has not been registered as yet. Please submit it that police is also accused applicants of which the instruct is very in the instant case has been produced for 3 weeks. It reveals that this is Mr. Sharma Borpeta PS case number 157, right?
Yes, yes.
Reveals that it reveals that case that's Borpeta PS case number 157/26 under section 109 in bracket 1 stroke 126 bracket 2 stroke 76 stroke 117 bracket 2 stroke 351 bracket 2 stroke 35 of ENS has been registered against the accused applicants. The is the related to the case of the previous case used with this court. This court, the same is produced by the court. But it is found that there are sufficient to come up with incriminating against the accused applicants. Against the accused applicants are available. It's not trying to grant any relief under the instant accordingly the instant application is dismissed.
Biplab.
28 Lordship, some of the petitions are interim. And Lordship, we have to update the CD Lordship. So way back in April Lordship, since it has not been updated Lordship. Statement is not there Lordship.
So statement, those who are getting my lord interim, they have already appeared, my lord, their statement has been recorded.
We'll update the CD Lordship. Some grievous injury part is there Lordship. Oh, so-
But CD, I mean, order was on 19/5/2006.
Yes, CD is up to Lordship. 20 to 4/26.
Let them come back.
My lord, those,
As Mr. P.J. Mohanpal, relevant senior counsel, assisted by M. Hope, relevant counsel for the accused applicants. Also by Mr. B. Sharma, relevant AP for the state. Mr. B. Sharma submits that post in case the same is not updated and an updated CD will be required for application of the matter. To place for some time to get the updated CD. Let the matter be fixed on when
Lordship, 24th.
some on the 24th. Let the matter be fixed on 24th. So
interim order pass.
interim order so past days continue the next day.
29 Lordship, CD has been received. Petitioner is on interim, he has appeared Lordship. And
The petitioner appeared and recorded his statement before the IROS.
So we'll allow them.
Lordship,
Heard Mr.
PP voter.
He brought about the learned counsel again, where he is applicant also heard solution of the learned counsel. He is in application under section 42 of the NSS, 2022, praying for grant of clearance to accused applicants in connection with 11 case number 196/2025 under section 61 2 stroke 314 stroke 316 bracket 2 stroke 318 bracket 4 ENS. This code by order 19/2026 has granted in relate to the applicant to the direction that accused applicant that appear before the investigating authority within 7 days of passing of the appropriate order, which learned counsel paying for the accused applicant submits that in terms of the appropriate order dated 19/5/2026. He has already appeared before the investigating authority and has been cooperating with the investigation. Mr. B. Sharma, an APP has also confirmed that the accused applicant has already appeared before the investigating authority. Taking into account the submissions and submission. This court is of the consultative opinion that the interim order so passed on 19/5/2026 should be made absolute. accordingly, accordingly, I think, what the infant clearest will order with the title, with with the same terms and conditions as mentioned in the procedure other than notified procedures. In the procedure terms, for instance, AV application is disposed of as allowed.
30 lordship, charge sheet has been submitted. I will not interim.
Oh, there and actually,
Lordship.
heard Mr. P. what about the learned council appearing like also these are not allowed to use the speak. This is an application under section 42 of the premises cannot be used for granting clear visible to the accused applicant being convicted. If 12 to CPS is number 20/2026 under section 329 bracket 4 stroke 117 bracket 2 stroke 305 small e bracket 2 stroke 88 stroke 63 stroke 2 bracket 5 of PRS 2088. The learned Mr. B. Sharma, the learned deputy appearing for the state submits that the charge sheet names is already been filed. By charge sheet number
20/26. Date lordship, we do not have the date lordship.
on the
Charge sheet number 20.
before the jurisdiction is of in view of the opposite, the extent the application is closed with the liberty to the is applicant to the jurisdiction court within a period of days. So 15 days from passing of the instant order, which is appearance for the jurisdiction court. Interim order so passed on 19/2026 self-contained. In view of the opposite direction, the instant AV application is disposed of.
31 lordship, CD was called for, it has been received. Here, if lordship kindly comes to the FIR, the allegation against him is lordship that he sold insecticide and pesticides to the
Girl,
lordship.
then the girl,
Yes. And subsequently she died. But main allegation is against number one. That's a different issue. But here, lordship, what I have found, lordship, the specimens were sent for FSL, lordship. There, the FSL report, it states, lordship, that the, in my opinion, the cause of death of so-and-so, opinion regarding cause of death could not be given even after thorough examination. No poison were found in the specimens, lordship. No, yes. Yes, no ethyl alcohol or common poisons were detected in the exhibits. The exhibits are lordship, stomach, brain, lungs, kidney, so-and-so, blood. No ethyl alcohol or common poison were detected in the FSL, lordship.
but the pesticides will not be containing ethyl alcohol.
Lordship, because common poisons or ethyl alcohol. Otherwise, lordship, it has been, the investigation has revealed that he has sold it. That is there.
I have a belief lesson, Lordship, in the market, Lordship, I sold the fertilizer along with the pesticide, Lordship. Many persons purchase the articles, Lordship. Lordship, I have never sold out any articles to the any minor, Lordship. And the affair filed after the 9 months, Lordship. The incident took place 14th of June 2025, Lordship. And after 9 months in the month of February, Lordship, filed the FIR, Lordship.
After the death.
Lordship. And they said that the justice has not been given. Subsequently, they filed this instant FIR, Lordship, implicating the petitioner.
Is there any enmity with you?
No, Lordship.
Why they have filed it?
Lordship, in the locality, Lordship, only my shop is the fertilizer and the insecticide, Lordship.
So let him go and let him cooperate with the investigation.
Lordship.
Okay, heard Mr. M.J. Shah, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned deputy for the state. This is an application filed under section 42 of BNSS, 2023, paying for grant of clearance bail to the accused applicant. Accused applicant, apprehending arrest in connection with Gauhati police case number 71/3026, registered under section 296 77 108 123 3 of the BNS 2023. An FIR was lodged. Next, an FIR was lodged on 9/2/2026, alleging that the accused applicant has sold certain fertilizers and insecticides clubbed with his grocery articles without license, and his minor daughter, after buying some fertilizers and insecticides, committed suicide by consuming the same. To stop. The learned counsel appearing for the accused applicant submits that the accused applicant is a license holder for selling of fertilizers and insecticides, and he has been doing this business for quite a while. He further submits that in the instant case, the FIR has been after 9 months of the incident of the alleged suicide. He submits that he submits that he has not sold any fertilizer or insecticides to the victim girl as alleged in FIR. The CD in the instant case is that in the instant case has been received along with the FSL report, and the same is produced before this court. After perusal of the FSL report, as well as the other materials in the case diary, this court is of the considered opinion that at this stage the accused applicant should be given the privilege of the arrest bail. Accordingly, it is directed that in the event of his arrest, in the event of the arrest of the accused applicant in connection with Gauhati PS case number 71/2026, he shall be released on furnishing of a bail bond of rupees 50,000 with a severity of like nature, subject to the satisfaction of the arresting authority, subject to the following conditions. Number one, the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. Semicolon. Next, the accused applicant shall cooperate with the investigation and make himself available as and when called for by the investigating officer. Next, the accused applicant shall not try to influence any witness that may be involved in the instant case. In terms of the aforesaid direction, the instant AV application is disposed of as allowed.
Charge sheet submitted, Lordship.
We'll go and appear.
May consider the Lordship since investigation is already over. Investigation is already over. No chance of tampering.
We go and appear if you are so advised. Not be say the learned counsel appealing for the accused applicant, also have Mr. B. Sharma, the learned APP for the state. This is an application under section 483 of BNS explained for granting clearance bill to the accused applicant in connection with Hattigam Police Station case number 23/2026 under section 305 in brackets small a of BNS 2023. An FIR was lodged with the officer in charge Hattigam Police Station on 27/1/2026, alleging that some miscreants had stolen certain boring parts from a godown of the informant situated at Sector Hattigam Police Station. Mr. B. Sharma, the learned APP has submitted that the charge sheet in the instant case has already been filed by charge sheet number
68/26 dated 25/5/26.
In view of the aforesaid, the instant AV application is closed with the liberty to the accused applicant to approach the jurisdictional court if so advised. And this instant AV application is disposed.
Okay. My lord, I'm not pressing this matter because I'm not pressing this revision, my lord. Because as per the court's order dated 19/7/19, he is supposed to deposit 2 lakhs and condition that after deposit, it will be admitted. But the petitioner has not complied with. So I'm not pressing this matter.
So you're withdrawing this?
Yes, let him suffer.
Heard Mr.
K. Bhattacharya.
The land council appearing for the petition. Also heard Mr. K. Das. You say you are appearing?
My lord, we are formal party, my lord, for the state of Assam.
Okay, Mr. K. Boyso for the land. You appear as an APP.
Yes, ma'am.
Run it APP for the state. Mr. Bhattacharya submits that he has instructions to withdraw the instant petition, full stop. The instant criminal revision petition is dismissed as withdrawn, as withdrawn. Dismissed as withdrawn, huh?
May I please, Your Worship? Wherein this criminal petition, my lord, I have challenged the proceeding, my lord, against the petitioner, my lord.
Please come in order. Why? Order. Why?
My lord, admission.
Come in admission. You check in this. Yes.
FIR was against the petitioner on under section 353, 120B and 507 of IPC. my lord.
Challenging what?
Challenging the proceeding, my lord. Your Lordship may kindly peruse my prayer, my lord. Is that face, my lord? 25, my lord.
Madam, before my learned senior colleague submitted, only one thing, my lord, I would like to point out, my lord, in this matter, my lord, here in this matter, my lord, that is the accused petitioner assailing, my lord, and for the classment of the entire proceeding, my lord. And one of the law point, my lord, is because, my lord, that is the content of the FIR, my lord, regarding a, my lord, SARS operation in a, my lord, that is, my lord, regarding, my lord, some ICDS, my lord, that is, my lord, rice, my lord, and my lord, other, my lord, the BPL and other, my lord, rice, my lord, allotted rice, my lord. In this regard, my lord, the main, my lord, that is the, my lord, law point is involved, my lord. They stated, my lord, in the petitioner, petition, my lord, that, my lord, that is the way, my lord, that is, my lord, they, my lord, did the SARS operation, my lord. It is not as per law. And, my lord, regarding that particular, my lord, point, my lord, in, my lord, page 23 of the petition, my lord. In page 23 of the petition, my lord, they, my lord, stated in, my lord, para, my lord, 8, my lord, last paragraph, my lord. Well, may I read out, my lord, that part only, my lord. For that impugn FIR dated 10/10/2023 is maliciously instituted against the petitioner with an ulterior motive for wreaking vengeance on the petitioner's family and with a view to spite them without any iota of the truth. Rather, the person present on 5/10/2023 were cooperating with the opposite party number 2 when the purported search and seizure of FP shop of the petitioner at the instant of the district commissioner Kasar, and their very actions are illegal and arbitrary, for which writ petition number 6053/2023 is still pending for final hearing before the Honorable Court. Now, my lord, regarding that, my lord, particular, that is the main vital point of law, my lord, regarding that part. Other sections are, my lord, from the IPC and CRPC, my lord. That is, my lord, dealt with, my lord. My lord, they have already filed a, my lord, WPC, which is pending before this Honorable Court, my lord, before filing of this criminal petition. My lord, 6053/2023, my lord.
That I have ordered already, and if I am allowed to submit my all these, I clear.
So he's just pointing out something.
And, my lord, that, my lord, order, my lord, may kindly peruse, my lord. It is, my lord, annexure, my lord, 28, page 42 of the petition, my lord. Page 42 of the petition, my lord. Order is started from, my lord, page 43, my lord. This is the first order, my lord, in the motion day, my lord. 11/10/2023 order, my lord.
Yes.
Heard so Mr. So learned counsel for the petitioner has submitted that the respondent number 4 on 5/10/2023 has made a search and says books of accounts, article, register, etc., including one set of keys pertaining to the godown maintained by the petitioner as a fair price of FPS dealer to keep articles under the control orders frame under the Essential Commodities Act 1955, the FPS run by the petitioner. Mr. Ghosh has contended that clause so-and-so of the Assam Public Distributions and Articles Order 1982 Rule 10(4) of the Public Distribution System Control Order 2001 have clearly prescribed that such search and seizures are being made as per the provisions of Section 100 of the Code of Criminal Procedure 1973, meaning thereby there must be two independent witnesses at the time of search and seizure. But in the case in hand, search and seizure were made in violation of the described procedure. And my learned senior colleague, my lord, he is appearing, Mr. Setia is appearing, my lord, in that matter, my lord, from the side of the government, my lord. So, my lord, it is listed, man. So, my lord, basic, my lord, that is, my lord, that is what my limited understanding, my lord. That is the, my lord.
So why you have filed this, Mr. Gauhati?
Yes, my lord.
You have
And
already filed already a writ petition.
My lord,
Challenging the seizure procedure.
exactly, my lord.
Correct. Now, then what remains in this matter?
I am not suppressing anything, my lord. I have,
No, you are not
everything is on act.
No, nobody is saying that you are suppressing.
Because, my lord, I have challenged this proceeding, my lord, since, my lord, the entire procedure they have adapted, and subsequently I was also arrested after the dishonorable court's protection order. They have arrested me in connection with this Lakshmipur PS case, my lord. Subsequently, they were arrested and released by this honorable court, and now proceeding is pending before the London SDGM, my lord. So, against this proceeding, my lord, since it's a illegal, my lord, and I will show your lordship and satisfy your lordship how it is
you
illegal.
See, one basic thing, the basic thing is that, I mean, you have filed the writ petition challenging the process.
That's different, my lord.
Search and seizure. And you are seeking quashing of the same proceeding here.
No, my lord, no.
Why not?
That's different, my lord. Since my soap was suspended after this search and seizure, my soap was suspended,
Yes.
and that has been challenged, and that is before the pending before the honorable court final hearing. But again, on the basis of that search and seizure, they have again penalized me under section 353 and 507, which is not applicable. In fact, my lord, on that day I was not present there. I was out of station. And I have annexed his railway ticket, my lord. How 353 will lie, my lord, when the entire procedure itself illegal? I will show you, lordship, my lord. If your lordship allow me to submit, my lord, or on another day, my lord, I will satisfy your lordship for disposal, my lord. Because, my lord, your lordship, their FIR, my lord, itself stated that, my lord, whether 353 is applicable. That is the abuse of process of the court, my lord, in fact. That is at page 37. That is the FIR, my lord. And point number 2, my lord, grounds in points number 2 at page 20, my lord, I have specifically stated this. What my learned friend has submitted, my lord. At page 20, your lordship pointed grounds.
So initially one FIR was filed, right?
Yes, my lord.
FIR was filed.
And then charge sheet.
Then charge sheet was filed. Seizure, this search charge and seizure happened when?
On 5th of, on the same day, my lord.
When the FIR was filed?
My lord.
When the FIR was filed?
My lord. Subsequently, after that, my lord, they have filed lodged this FIR.
Before FIR was filed, the search and seizure was done.
Yes, sir.
Then
the search and seizure procedure, my lord, this happened. That is why FIR was filed.
FIR lost on, my lord, Registered on, my lord, 10/10/2023. And search and seizure done on 5/10/2023.
So basically the FIR is the consequence of your search and seizure, right?
Exactly, my lord.
So once your search and seizure goes, the FIR goes.
Yes. Yes.
So
That part is,
you have challenged this in the
that part is correct, but learned court, which when I have submitted the court order, your lordship may found at page 74.
Yeah,
The learned court have already taken cognizance.
Oh,
Learned subdivisional judicial magistrate first class.
so correct, that has been taken. That is an independent thing. That's a different thing. But once your repetition is allowed, then what will remain in this case?
It may remain, my lord, FIR and charge sheet, my lord.
No, if your the whole search and seizure is set aside by the court,
My lord.
terming that illegal, then what will happen? Consequently, what will happen? Your FIR will go. Consequently,
350, 353 and 350, 507 is there, my lord.
what is 353?
350, your lordship, may. That's why I have challenged this, my lord. Your lordship, may 353 kindly.
353 of IPC or BNS?
IPC. It proceeding is different, my lord, and criminal provision is there, my lord. Your
You
lordship,
cannot file writ and criminal and on the same matter, same cause.
no, my lord. Your lordship, may kindly.
It's a different proceeding. See, the criminal proceeding is different and writ proceeding is different. This court is aware of this. Correct. Court is aware of this. But we are asking is that whether you have filed both the petition the same cause of action.
No, my lord.
Because you have challenged this search and seizure.
No, a search and seizure along with they have sealed my shop, my lord. That's a different cause of action. My lord, if your lordship, may, I will show your lordship. My lord, kindly.
What's
353?
Tell me.
353, your lordship. Whoever assaults, may I read, my lord?
Yes.
Whoever assaults or uses criminal force to any person being a public servant in the execution of his duty, as such public servant, or with intent to prevent or deter the person from discharging his duty as public servant, or in consequence of anything done or attempted to be done by such person in the lawful discharge of his duty.
The correct understood. This happened while the search was done, right?
Done. Exactly, my lord.
So was done. So allegations have been made that like you tried to obstruct them or assaulted them, whatever. Now you have challenged that search and seizure in the repetitions. The process. If the court comes to say that search and seizure is illegal because it was not done in terms of the
But whether continuance of the criminal proceeding, my lord, itself a abuse of process of the court, my lord. Since Lana court has taken
that is
cognizance of the matter.
you have already challenged that in the
That was not challenged, my lord.
petition. You have
Only petition in respect of my suspension and their search and seizure, and they have seized all things and sealed my shop, my lord. So that's a different cause, my lord. And in this case, my lord, I will show your lordship how the abuse of process of court is going on.
Yes, Mr. Busho, I think we can get this.
Yes, my lord.
My lord, regarding that part, my lord, regarding these two, my lord, sections, my lord, 507 and my lord, that is another section, my lord, 353, my lord. In these two sections, my lord, clearly from the FIR, my lord, it reflects, my lord. From the FIR itself, it reflects, my lord.
No, that's what he's telling
Yes,
you.
my lord. That part, my lord, is there. But my lord, basic is, my lord, regarding, my lord, that is the FPS shop, my lord. That is, my lord, there is a AAY, my lord, onto the Anno Yojana, my lord, right?
Not on this, my lord.
These things are on the, my lord, basis of
criminal proceeding, my lord.
Yes, my lord.
I
let
have
it
not
submit,
this,
my
my
lord.
lord.
Then.
And I will satisfy your lordship, my lord, on that count. That it is a abuse of process of the court, my lord.
Let us see the FIR first.
My lord, FIR is at page, my lord. Page 37, my lord. Lordship got it?
One second, one second. Yes.
With due respect to kind honor, I would like to inform you that yesterday, that is on 5th of October 2023, I made a sudden visit to the FPS shop of Rakesh Singh. That is the petitioner, my lord. License number such and such under Lakipur GPSS situated in Borobil, Lakipur in the afternoon for an inquiry as per your instructions, and she write this letter to the deputy commissioner, my lord. Instruction and complaint petition in reference. Upon my arrival, I came to know from some local villagers that the shop is located beside the national highway adjacent to the Chiripul bridge. As the shop was closed, I called Sri Binayam Krishna, Inspector FCS and CA Lakipur to the spot and to connect the contract the FPS dealer to the shop. Later, she informed me that the shop is located in Koilapur and the shop where I was present was an extension of the same. So I reached the shop within next few minutes. The inspector along with the sub-inspector Sophia Loskor were already present in the spot. A nominee named Harnam Singh was present there on behalf of the dealer, namely Rakesh Singh. Upon observing stock board, I found that the stock update as the date was written as PH rice 50 kg, AOY rice 35 kg, ICTS kg, 435 kg. But there was no rice stock in present of the shop. I asked the nominee to show the physical stock, to which the nominee replied that those were in the extension point shop. Thereafter, all of us went to the extension shop. To my utter surprise, there was only 235 kg approximate. There was no stock and price board and identification board in the so-called extension shop. When asked the nominee unable to show me the physical stock as per the enlisted data in that shop and was not able to justify the anomaly. Furthermore, the anomalies were also noted in the stock register. The sale register were also not maintained properly. So I told the nominee, namely Harnam Singh, to write a statement mentioning the same findings. He wrote, signed, and gave the sheet paper to me. Later on, out of nowhere, where telephonic conversation and nominee snatched the statement from my hand, which he had already submitted to me. When I asked it back, he was not at all willing to provide the same to me and started verbal spat. One of his men, namely Prabhat Singh, started videographing, photographing, and scene, and also my official vehicle. Even after I asked him to stop videographing, he did not listen and continued the same. Finding myself helpless matter and communicated to your and our phone. Around the same time, that is the main point, my lord. Around the same point of time, there was a multiple phone calls from the unknown number. Number is that 9435175657. When I picked up one call from the same unknown number, such and such, the caller identified himself as Rakesh Singh. That is he's the petitioner, my lord. Very surprisingly, he want to mention my place of origin and community to which I belong, etc., and was about to say many things which were totally personal, unnecessary, and not all related to the inquiry. Thereafter, call got disconnected. Upon your instructions, Sri Sudipnath, SCS, SDS, Lakipur, reached the spot within the short while, and the police arrived soon after. The videography ended only when Sudipnath, SCS, such and such, instructed strictly in presence of the force. Thus, we will come back to the spot safely, and all necessary registered documents relating to the dealer that was furnished were brought with us. In the evening, the nominee, namely Harnam Singh, confessed in writing in front of the undersigned Sudipnath, SCS such and such, and Binayam Krishna, Inspector such and such, and that he snatched the paper containing the statement based on the verbal instruction of the dealer Rakesh Singh over phone call. His confession cum apology letter is attached herewith for your ready reference. Furthermore, I am attaching the necessary supporting photograph from the spots. The FIR is registered and received and registered, my lord, as under section 120B and 353-507. And accordingly, police have submitted the charge sheet, my lord. Charge sheet has page 6, annexer 16, page 70, my lord.
Sir,
Annexer 16, page 70, my lord. 70, my lord. FIR dated 10/10/2023, final report dated 31/12/23, my lord. Petitioner along with two other persons, another person was implicated in this case, my lord, that is. And witnesses were there, my lord, at page 71, my lord. That is the informant, and Sudipnath, that is the Benayan Krishna. They all are officials, my lord. There is no independent witness, my lord. Page 72, your lordship may brief facts of the police, my lord.
72 what?
Page 72, my lord.
Hmm.
Brief facts of the case, my lord. That is in the last
During investigation,
my lord.
bottom part.
Bottom part, my lord. During investigation, the prima facie case is well established under section 120B 353-507 against the accused arrested. Accused persons accusing he was earlier arrested, my lord, by the police, my lord. Railway gate and the absconding accused, Prakash Singh, but other accused number 1, Prabhat Singh is absconding, my lord. I beg to send them up for trial under the aforesaid sections and WA. In the name of the absconding arrest, Prabhat Singh may kindly be issued to appear him during the trial. Witnesses.
Is there any stay order in this case?
My lord?
Is there any stay order?
No, my lord. In fact, my lord, what my learned friend has been submitted, my lord, a petition regarding his hope and other things. And here I am approaching before your lordship against the criminal proceeding, my lord.
Who is appearing for respondent number 2? You are appearing.
Since, my lord, in the writ petition, we have not challenged the FIR, my lord. Only inquiry, and FIR is still there. If writ petition is allowed, FIR itself is there, my lord. Criminal proceeding will be continued, my lord, against me. Yeah, in the writ petition, my lord, we have not challenged the FIR, my lord. We have challenged the different thing, my lord. Here I have challenged the FIR and charge sheet and entire proceeding, my lord. Since if the ultimately petitioner is not present on that day, my lord, so 353, in fact, not attracted so far as I will satisfy your lordship, and so far as other sections also not attracted. So even, my lord, the criminal proceeding is continued. It will be abuse of process of law ultimately, my lord.
Okay, we'll take it up after
My lord,
at 2 o'clock.
my lord.
May I take your lordship indulgence for a moment, your lordship? I'm sorry, your lordship, I could not mention the mentioning time, your lordship. Item number 39, your lordship. Can it be taken up on Friday, your lordship?
You are appearing for whom?
I'm fully appellant, your lordship.
Appealing.
I have informed the other side also, your side, on Friday. I could not prepare the case today.
Friday it will be difficult. Friday.
Then Monday, your lordship.
On the prayer of Mr. S. Portable, the Lord Civil Council appearing for the appeal. Later at listed on next Monday, it is on. That is on 15th.
Lords.
In June. He submits that he has already taken the council of the council.
Second of Monday. Okay, item 9, but second of I note with the I to go somewhere else now. Any day, day after tomorrow, day after tomorrow, according to the lordship's.
Next week.
Any day, my lordship.
Heard Mr. Richard Sokuri, and then senior counsel appearing for the respondent, appearing for the.
Respondent, Mr. Nawaz is appearing as a respondent number 2 now.
Appearing for the petition submits that the place for adjournment of the matter and place for adjournment of the matter and we listed on, yeah, and we listed after the week.
One small question, my lord.
And now
Lord, I am appearing as an amicus for the respondent number 2. My name has not been shown in the cause list, my lord.
Learned counsel has appeared on behalf of respondent number 2 as an amicus. Let the matter be listed in next week. When raised it to show the name of Mr. S. Nawaz, the amicus could be appearing for respondent. The cause list. Let the matter be listed in the next week.
Deeply obliged, my lord.
Yes, page.
Page, NSR 16, page 70, my lord. Your lordship got it.
Yes.
Page 70, my lord, the FIR registered on 10/10 and charges submitted on 31/12/2000, bottom, above of the email. That is it, page 70, my lord. And contents of the FIR, my lord, page 7, sorry, charge sheet, my lord, page 72, my lord.
Yes.
Page 72, my lord, bottom, my lord, last part, my lord. During investigation, the prima facie case is well established under section 120B 353 and 507 IPC against the said arrested persons, Rakesh Singh, son of such and such, and the absconding accused Prakash Singh. He is not challenged this FIR, my lord, near Railway Gate, PS Lakshmipur District, Kachar Assam. So I beg to send them to face trial under the aforesaid sections of law and warrant of arrest in the name of the absconding accused, that is the Prakash Singh. Rakesh Singh was earlier arrested, my lord, petitioner. May kindly be issued to appear him during trial. Witnesses 12 report. And then, my lord, next page in the page 74, my lord. Annexure 17, my lord, the order was passed on 4/11/2024, my lord. Case record along with the original case diary has been received on transfer disposal from the learned SDJM Kachar, SDM Lakshmipur Kachar. Investigating officer has filed the charge sheet against the accused Rakesh Singh and Prabhat Singh such and such under section 120B 353 507 IPC. FIR as a rough sketch map of PO have been annexed to the charge sheet. Accused persons are on bail. Produce the case record and report submitted by the investigating 173 relevant documents annexed thereto thereupon. I am considered opinion that there is a sufficient ground for proceeding against the aforesaid accused persons under section 120B 353 507 IPC. Accordingly, cognizance of offense under section 120B 353 507 IPC has been taken against the aforesaid accused persons, and that PRC case is still pending, my lord. For service of copy, my lord.
He is still pending.
My lord.
Is still pending.
My pending. Now, my lord, your lordship may kindly again produce the FIR at page 37, my lord.
No. Yes.
That was to the Deputy Commissioner Kachar Silchar. Incident report of the information event that took place during an inquiry. That is the FIR. And under section 154, my lord, there is a FIR. That means it's a form of a letter, my lord, addressed to the officer in charge concerned, my lord. But here, my lord, that FIR that was registered by the police, my lord, that is addressed to the Deputy Commissioner. And section 154 itself, my lord,
154 says what? 154 of?
My lord, one CRPC, my lord.
BNS, what is now? What is this is under what? Hmm.
154, may I read, my lord? Like it off.
Yes.
Every information relating to the commission of cognizable offense, if given orally to an officer in charge of a police station, shall be reduced to writing to him or under his direction, and be read over the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by the officer in such forms as the state government may prescribe in this way. What I am trying to submit before your lordship, my lord, that was addressed to the district commissioner, my lord. And here section 154 is totally clear, my lord, that it should be addressed to the officer in charge of the police station, my lord. Either orally or in writing, my lord. Now, my lord, I am your lordship's APT order 19 about how they have violated the provisions of law, my lord. Issue your lordship, my lord.
But this later on sent to Lakhiru police station.
Police station, my lord.
The police has registered the case.
Registered the case accordingly. This one registered, my lord. There is no separate FIR.
Correct. This was forwarded to the police officer.
Police officer, my lord. But they have registered the same, my lord.
Correct. Is there any bar in this?
And another aspect, my lord, I will show your lordship, my lord.
If it is sent to the DC or any police officer, and the same is sent to the concerned police officer to register a case, that cannot be done.
My lord, in fact, my lord, it's as per, my lord, it is the inquiry report, my lord. Inquiry report cannot be treated as FIR, my lord. That may be. But it should be reduced to writing in an FIR, my lord. And in the FPTA order, my lord, I have just given to your lordship, my lord. Your lordship may kindly peruse the clause 31, my lord. What is the requirement for search and seizure of a FP shop, my lord? Clause 31, your lordship. Clause 31. Designation is not there. Lordship got it, my lord. And the last, my lord, above the clause 32, my lord, the provision of section 100 of the criminal procedure.
Where?
Next page, my lord. 31, next page, my lord. Last.
Which paragraph?
Last paragraph, my lord.
Last paragraph means now is there a number?
31, in fact, my lord, 31, A, B, C, D, E, F, G, H, and then, my lord, that provision. Lordship got it. The provision of section 100 of the Criminal Procedure Code relating to search and seizure shall so far as may be applied to search and seizure under this clause, but that was not followed. And under yes. And then again, my lord, we should come to CRPC, my lord, under section 100, my lord. Subsection 4, my lord. Yes. Before making a search under this chapter, the officer or other person about to make it shall call upon two or more independent and respectable inhabitants of the locality in which the place to be searched is situated, or of any other locality, or no inhabitant of the said locality is available or willing to be witnesses to the search and to attend and witnesses the search, and may issue an order in writing to them or any of them to do so. But in my case, that was not done. That there is only officials. I have not present, but there is some officials, my lord, are there. In this respect, I would like to, my lord, rely on judgment of the Honorable Supreme Court, my lord. That is, my lord, AIR 1960 Supreme Court 2010, my lord. That is in respect to Central Excise and Salt Act, my lord. There is also a provision when the authorized officer is going to search for a shop, he has to obtain a warrant, my lord. In that case, also Supreme Court held that in the event of non-issuance of any warrant, my lord, in that case it will be illegal. That is at para 7, my lord. Para 7 and 8, my lord. Now, your lordship, now we shall look at the provisions of Criminal Procedure Code to ascertain which of its provisions relating to the code mode of search or appropriate to the power conferred on the deputy superintendent under Rule 201. That is in respect of my case in 31, my lord, in APTA order. In the Criminal Procedure Code, there are four groups of sections regulating the search authorized under it. Section 47, 48, 51, 52 appear in Chapter 5 of the Code, which provides for for the arrest, escape, or retaking of the person. Section 47 provides for search of a place entered by the person sought to be arrested. Section 48 for procedure where ingress is not obtainable, and section 51, 52 for search of the arrested person. The second group consists of section 100, 101, 102, and 103 of chapter 7 of the code. That is the old code itself, my lord. The section 100 deals with the search of for person wrongfully confined, and other section are general provisions related to search warrants, duties of persons in charge of closed places, and requisitioning of persons to witnesses searches. Section 53 forms the third group, and it falls under chapter 13 of the code, which provides for the preventive action of the police. Under section 53, police officer can make a search without the warrant for the purpose of the inspecting or searching for any weights, measures, or instruments for weighing used to or kept within the limits of his station, if he has reason to believe that the weights, etc., are false. Fourth group of the sections appear chapter 14, which provides for search by the police officer during the investigation. Yeah, of a cognizable offense. Power of search given under this chapter is incidental to the conduct of the investigation. The police officer is authorized by law to make. Under section 165, four conditions are imposed. One, police officer must have a reasonable ground for believing that anything necessary for the purpose of an investigation of an offense cannot, in his opinion, be obtained otherwise than making a search without undue delay. Secondly, he should record in writing ground of his belief and specify in such writing so far as possible the things for which the search is to be made. And three, my lord, he must conduct the search if practicable in persons. And four, if it is not practicable to make the search himself, he must record in writing the reasons for not himself making the search, and shall authorize the subordinate officer to make the search after the specifying in writing the place to be searched, and so far possible the thing for which the search is to be made. As such is processed exceedingly arbitrary in character, stringent statutory conditions are imposed on the exercise of power. A comparative study of the aforesaid provisions with the provisions rule 201, that is excise rule, my lord, of the rules, that is in my case, my lord, clause 31. Indicates the search made by the police officer during course of investigation of a cognizable offense can properly be approximated with the search to be made by the authorized officer under section 1 of the rule 4. And former case, the police officer makes a search during the investigation of a cognizable offense, and the later authorized officer make the search to ascertain whether a person contravened the provision of the act or rules, that is section clause 31, my lord, which is an offense. There is also no reason why the conditions should be imposed in the matter of a search by a police officer under section 65 of the code, but no safeguard needed to be provided in the case of a search by the excise officer under rule. We think that the legislature, by stating section 18, that is the excise act, my lord, of the act, that the searches under the act and the rules shall be carried out in accordance with the provisions of the code relating to searches. That is in my case, clause 31 of the APDA order, my lord, clearly indicated that the appropriate provisions of the code shall govern searches authorized under the act and rules, and we therefore hold that the provision 165 of the code must be followed in the matter of searches under rule 201. In my case, rule clause 31, my lord, of the rules. Para 8, my lord. There is no merit on the second condition either. Recording the regions does not confer the officer jurisdiction to make a search through, though it is necessary conditions for making a search. The jurisdiction or power to make search is conferred by the statute and not derived from the record of regions. Apart from section 18 of the act, no express term states the searches shall be carried out in accordance with the provisions of Code of Criminal Procedure. Section 65 of the code lays down the various steps of following in making the search. Recording of regions is an important step in the matter of search, and ignored it is to ignore the material part of the provisions governing the searches. If that can be ignored, it cannot be said that the search is carried out in accordance with the provisions of the Code of Criminal Procedure. It would be search made contravention of the provisions of the code. Why I have to rely, my lord, section clause 31, my lord, because their search itself, my lord, it's illegal. So a penal provision under section 353 and 507 120 will not lie against me. And above all, my lord, I was not present on that day.
What is the material you were not there?
My lord,
That you were not there, is there any material before this court?
yes, please. I have placed the annexer, my lord, my train tickets and at page annexer 6, my lord, page 39, my lord, my train ticket. That is on page 39. Lordship got it? That is on 2/10/2025. But search was taken place on 5/10/25. My name at serial number 6, my lord.
Search was made on
5/10/23, my lord. He went to Uttar Pradesh for Pindodan of his father and mother, my lord. That I have also annexed the Bharat Sevashram Sangha identity card for pilgrims, my lord. On the next page, my lord, at page 40, my lord, Annexure 7. That was issued on 4/10/23, my lord.
You went to Silchar to Prayagraj
Prayagraj, my lord.
on departure at
2nd of October, my lord, 2023.
the arrival 4 October.
Arrival ticket I have also annexed, my lord. On his arrival, he was arrested. That is arrival on page 49, Annexure 10, my lord. That is Gauhati to Silchar. He first come down to Gauhati and then going to Silchar, my lord, on 13th of October, my lord. And 14th, he was arrested. And regarding his, my lord, statement about the Pindodan of his mother and father, I have also annexed the identity card of pilgrims, my lord, at page Annexure 7, page 40, my lord, type copy and with the original copy, my lord.
Page
40, my lord, Annexure 7. On the next page, they are received, my lord, receipt copy that I have typed, my
there
lord.
is somebody else, Amar Das.
Omar Das along with him, my lord.
Where?
Omar Das in the ticket, my lord, his name is there.
No, where is his name?
Departure ticket, my lord, 2nd of October, my lord, page.
That is there.
Page
But like
39.
that, Bharat Sevashram, I mean, how who is this Amar Das?
My lord, Omar Das is in fact, my lord, they are all 6 persons have went to Prayagraj. His name is there at in the train ticket, my lord. And the statement also, my lord, in the FIR itself also, he was not present and he ring that official, my lord, informant, my lord. And his bail order is at page, my lord, your lordship may. Found it at page 65, Annexure 14, my lord. Page 14, your lordship. That he was released on bail, he was arrested, my lord, and he was released on bail 19/10/23, my lord.
He was arrested on 13.
He was arrested on, my lord, 14/10, my lord. (14/10), my lord. Arrest memo I have also annexed, my lord. He is released by this honorable court on 19/10, my lord.
Then
So far as, my lord, grounds taken in my criminal petition, my lord, your lordship may kindly peruse this, my lord, at page 20, my lord.
Page?
Ground number page 20. Grounds number 2, my lord. What that the proceeding initiated against the accused petitioner on the basis of purported inquiry by the FP number 2, Assistant Commissioner Kacha Silchar, wherein informant OP number 2 on 5/10/20 searched the fair price shop of the petitioner for purpose of inquiry. But any search in the fair price shop will be governed by provisions of Assam Public Distribution Article Order 1982. Under Article 31H, the Article Order 1982 provides that provisions of Section 100 of the Criminal Procedure Code relating to search and seizure shall, so far as may be applied in to search and seizure under this clause. But the search and seizure had been done by the OP number 2 in violation of Article Order 1982, which requires complying the provisions of Section 100 of CRPC prior to any search and seizure. Therefore, entire inquiry is illegal arbitrary in view of the specific provisions of law. Thus, to constitute the offence under Section 353 requires the lawful discharge of duty by the public servant. Therefore, OP number 2 being Assistant Commissioner come Executive Officer Purchase Center without following the due process of law entered the office of the petitioner in such section of the OP number 2 cannot be said to be a lawfully discharging the duty. In view of the above, the impending proceedings initiated by the learned Chief Judicial Magistrate, first class Kachar, liable to be quashed, set aside and quashed. And then, my lord, I have also taken regarding the FIR, my lord, on the basis of that at ground number 3, my lord. 3, 4, and 5, and 6, my lord. Okay. Yes. My lord, I'd like to rely some judgments, my lord, of Honorable Apex Court, my lord. First judgment is 2001 8 SCC 554 regarding the harmonious construction, my lord. बाकी कोई तो दिया था मैंने कोई नहीं तो बेटा से paragraph 8, my lord. It is settled, lordship got it. It is settled that for interpreting a particular provision of an act, the import and effect of the meaning of the words and phrases used in the statutes have to be gathered from the text, the nature of the subject matter, and the purpose of intention of the statutes. It is the cardinal principle of construction of the statute that the effort should be made in construing its provision by avoiding the conflict and adopting harmonious construction. The statute rules made thereunder should be read as a whole, and the one provision should be constitute with the reference to the other provisions to make the provisions consistent with the object sought to be achieved. The well-known principle of harmonious construction is that the effect should be given to all the provisions, and construction that reduces one of the provisions to a dead letter is not a harmonious construction with respect so and so. Why I have been referring this, my lord, since my lord 31 provides the provisions for section 100. That was not followed when my shop was searched by the authorities. So they should follow this, my lord, and then they have to search my shop. In that case, section 53 and 507 and 120 BIPC will not attract against me, my lord. And in respect of another judgment,
Ambiguity in that. Why this case is required?
Ambiguity because, my lord, they have not followed the procedure.
They have not followed, that's a different thing. But like he says about like interpretation of statutes, and when there is an ambiguity, how it is to be interpreted. So that it has nothing to do with that case. With your case, your case is you're saying
I
that
understand.
there's a violation of,
I understand this, Bill.
but there is no, I mean, ambiguity in that.
What I am trying to, before your lordship,
There is no ambiguity in that. There is a specific, I mean, provision that section 100 has to be.
exactly,
applied.
madam.
So that is not complied with, that is the case. But it's nothing like there is some interpretation issues there.
And no, it's not politics, it's not of my lord, and another judgment of our High Court 2005 supplementary GLT 532. What I did yan?
Yes.
2005 supplementary GLT 532, my lord, that is in respect of my lord 482. Para 8 and 9, my lord. What happened? And another two judgment, my lord, in respect of section 353 and 504, my lord. Para, my lord. Nineteen 86 SC Patna 165, my lord, para, my lord, 5, my lord. That is in respect of 4 and 5, my lord, in respect of 507, my lord.
In respect of section.
Section 507, my lord.
Which para?
Para 4 and 5, my lord. And another judgment I have forwarded, my lord, 2024 Supreme SC 1110, my lord. That is in respect of 353, my lord. Para, my lord, 5 and 6 and 7, my lord. Basically, what I am submitting, my lord, I was not present at the time of incident, my lord. So, my lord, 353 and 507 will not attract, my lord. And another thing, my lord, in the morning, my lord, my learned friend had submitted that I have
507 is what?
507. 507, my lord, 1986, Supreme Patna 165.
No, 507 is what? 507 of IPC.
4 and 5. IPC, my lord. IPC. (1986) Supreme Patna 165, my lord. That is Patna Rachi bench decision, a single bench judgment, my lord. There are 4 and 5, my lord. And section 5, it's 7, my lord, of 507 of IPC, my lord. Criminal intimidation by an anonymous communication. Whoever commits the offense of criminal intimidation by an anonymous communication or having taken precaution to conceal the name or abode of the person from whom the threat comes shall be punished with the imprisonment of either discretion for a term which may extend to 2 years, in addition to the punishment provided by the offense by the last preceding section. In fact, my lord, he has not nothing concealed. When his shop was searched by the officer, my lord, he called her and given her name, my lord, and asked about the purpose of the search, my lord, when he is staying at Uttar Pradesh, my lord. And another thing, my lord, your lordship, my lord, from my office copy, my lord, regarding the WBC number 6053, what my learned friend in the morning submitted before your lordship about the inquiry. My lord, in 6053, my lord, what we have challenged, my lord, only in respect of was the collection memo dated 5/3/2023.
Was the
Collection memo during the search, my lord. And secondly, mandament should not be issued directing the SMA 3 to 5 to release the original documents of the petitioner and also remove the seal of the petitioner's typeface. We have not challenged the inquiry report of the informant, my lord. Allow the petitioner to operate the fair price shoot till inquiry is completed by the respondent number 2 as per direction of the Honorable Court dated 23/2/22 passed in WPC number such and such. Your lordship, may allow me, I'll give you my office copy, my lord, that is that petition.
prayer?
Prayer portion.
Okay, that's fine. Okay, not required, not required.
That is my humble submission. So I am praying before your lordship for quashing of the entire proceeding.
So basically 353, 507 and 120B.
My lord.
120B, 553.
120B, in fact, my lord, not applicable since he is not there, in fact, my lord. And I have also annexed this document so when he is at Uttar Pradesh, my lord, for Pindonan of his mother, my lord. When person is not there, my lord, then how 353, 120B and 507 will be applicable, my lord? And merely on the basis of an inquiry report, which I have indicated before your lordship to the deputy commissioner, and that was forwarded to the officer in charge who registered the case without any preliminary inquiry or without any, and subsequently he was arrested by them, my lord, on 14/10, and this honorable court released him on bail on 19/10, my lord, after 5 days, my lord. My humble submission is that it will be abuse of process of the court, my lord. In fact, if the proceeding under these sections will continue, my lord. That is PRC case number 305 of 2024, my lord. PRC case number 305 of 2024.
Yes.
What I understand, my lord, three things are, my lord, that is submitted matter. First, my lord, regarding the FIR matter, lodging of the FIR. It is a question that there is a inquiry report, but in the subject it is stated as the incident report that is addressed to the deputy commissioner from the officer contract. And it is stated that as per law, it is not an FIR because it is not addressed to the officer. That was the first clue. Second, my lord, what my lord in the my lord very beginning of this matter, my lord, why I have submitted matter regarding the part of the WPC, because that part is regarding my lord, that is the search and seizure procedure adopted matter or not matter by the my lord, that is the authority matter during the when my lord that was my lord taken care of. In this regard, my lord, that is the second part, and third, my lord, that is the whether the ingredients matter. Of the three sections are, my lord, there in this matter, my lord, whether these are, my lord, prima facie established or not, my lord, whether it is a case for, my lord, crossing over. Now, my lord, regarding the first, my lord, that is the reply from the side of the prosecution that whether it is amounts to an FIR or not. My lord, in the record, may kindly, my lord, see, my lord, I have, my lord, three fragments are there. First, my lord, that is, my lord, where, my lord, that is the subject matter of the incident is described, my lord. My lord, what is, my lord, stated by my learned friend is the inquiry report, my lord. Where, my lord, on the, my lord, from that, my lord, particular, my lord, incident report, it is very clear as instructed by the, my lord, district commissioner, my lord, to conduct an inquiry, my lord. The lady officer went to a place, my lord, and, my lord, something, my lord, happened, my lord. Because of that, my lord, she informed her higher authority, the district commissioner, stated regarding the incident matter. That is the incident happened on, my lord, that is 5/10/2023, and, my lord, that is the incident report she submitted on, my lord, 6/10/2023 to the district commissioner. I have, my lord, flag mark, my lord, as a, my lord, original incident report, my lord, in the, my lord, flag, my lord. Three flag marks are there, my lord, very beginning of the record, my lord. Now, my lord, when, my lord, the district commissioner received that incident report, my lord, he, my lord, forward the same to the superintendent of police, my lord, write a letter dated 7/10/2023, my lord. That is also, my lord, flag mark, my lord. To take action, my lord, as per law, my lord. As because, my lord, something has come to his notice, my lord. He immediately sent write a letter, my lord, dated 7/10/2023 to the superintendent of police of the concerned district. That is also, my lord, flag mark, my lord. After that, my lord, the concerned superintendent of police, my lord, write letter dated, my lord, 9/10/2023, my lord. Send that particular communication to the, my lord, officer in charge of the jurisdictional police station, my lord, to, my lord, take action as per law, my lord. That is up to, my lord, 9/10/2023, my lord. And after that, my lord, FIR is lodged, my lord, on, my lord, 10/10/2023. My lord. So, my lord, my lord, limited understanding, my lord, is a FIR, my lord. All communications are made, my lord. SP himself, my lord, sent it to the, my lord, OC, my lord. As because, my lord, in a, my lord, when she is discharging, the lady officer discharging her duty, the capacity of a, my lord, public servant, my lord, at that point of time, something has happened, my lord.
What something has happened?
My lord, because she was, my lord, restrained, my lord.
Where is that?
Yes, my lord. My lord, may kindly peruse the, my lord, that is, my lord, the incident report, my lord. Page 37, my lord. Page 37 of the petition, my lord. Page 37 of the petition, my lord.
Page 37 seconds says what?
Bottom part, bottom part, my lord. My lord, before that, my lord, why, my lord, see when they are, my lord, because of, my lord, that is the fair price shop, my lord, there, my lord, see when, my lord, made the query, my lord, as per, my lord, the deceased, my lord, inquiry, my lord, she found, my lord, there are total, my lord, 435 kgs of my lord rice, my lord. And total, my lord, that is from IC, my lord, that is ICDS, and others from my lord AAY, and my lord, that is the priority household, my lord PHS. Total, my lord, 520 kgs of my lord rice were there, my lord. And my lord, she didn't find, only she found, my lord, that is my lord 235 kgs fine. The rest, my lord, 285 kgs were not, my lord, found, my lord. That is, my lord, the first beginning of the case. When, my lord, that part has happened, my lord, now, my lord, later part of the, my lord, that is the incident report, my lord. So I told the nominee, Harem Singh, to write a statement monitoring the same finding. He wrote, signed, and gave a sheet paper to me later out of nowhere. After telephonic conversation, the nominee states that statement from my hand, which he had already submitted to me. My. So that is the nominee of the present accused petitioner, my, who was at that point of time minus present. My. When I asked it back, he was not at all willing to provide the same to me and started verbal stuff. One of his men, namely Prabhat Singh, started videographing, photographing the scene and also my official vehicles. And even after I asked him to stop videographing, he did not listen and continued the same. Finding myself helpless, the matter was communicated to your end over phone to the district commissioner. Around the same point of time, there were multiple phone calls from one unknown number. Number is there, my lord. When I picked up one call from same unknown number, so and so, the caller identified himself as a Rakesh Singh, the present accused petitioner. Very surprisingly, he went on to mention my place of origin, the community to which I belong, etc., and was about to say many other things which were totally personal, unnecessary, and not at all related to the inquiry in hand. Thereafter, the call got disconnected. Upon your instruction, Sri so-and-so, SCS SDO Civil, Lokkhipur, reached the spot within a short while and the police arrived soon after him. The videography ended by Sri Sudip Nath, SCS so-and-so, Lokkhipur, instructed. And while in the evening, nominee namely Hare Ram Singh, confessed in writing in front of the Sri Sudip Nath, SCS SDO Civil, Lokkhipur, and Binayam Krishnan, Inspector, Food Civil Services and Consumer Affairs, Lokkhipur, that he snatched the paper containing the statement based on the verbal instruction of the biller, Rakesh Singh, over phone call. Well, that was the minor incident. Now, minor, there are two parts, minor. One, what is salience in the minor assailed in the minor particular writ petition before filing of this criminal petition. That is the part of the minor what minor provision of law should be adopted during carrying a minor search and seizure or inquiry. Minor. That is a different part, and that is minor before minor this honorable court minor. It is yet not minor disposed of matter. Now, my lord, here, my lord, the sections, my lord, when a my lord lady officer, my lord, she is, my lord, carrying her duties, my lord. That is my lord struck.
But whether it has been done under other sections, section 100. SARS is fine. SARS we have done. Whether we have done in compliance with section 100 or not.
Whether section 100 has been complied or not, it is the salience that is the same matter.
No, that is different thing. But here also like SARS has been made. Challenge, if you do challenge or do not do challenge, do not challenge, it's a different thing. But
here you cannot challenge the
but whether
section 100 of the CRPC matter.
no, whether you have done it as per CRPC or not. That is one of the main grounds. One of the main grounds he has taken on this. Huh?
He only challenged only the charge sheet matter.
Charge sheet and FIR.
Charge sheet and FIR.
Correct.
FIR was subsequent to the death.
Correct. Then like, I mean, but SARS has been done properly or not, that has also been one of the ground, his ground.
One of the grounds he only mentioned, my lord, that is a part of the writ petition, my lord.
No, my lord, writ petition is not connected with this. I have a copy of the writ petition.
But here,
You see the writ petition, what is there?
He challenged the
You see the
section
you see,
proceeding in the writ petition.
see the prayer, na? Prayer person, you see.
In the writ petition, he has challenged, my lord. He has not challenged These 100 sections here.
No, my lord, why I have to
Specific
challenge in this proceeding, my lord? Since that section is not applicable against me, that is my challenge, my lord. 353, whether 353 is legally enforceable when she is discharging her duty, my lord. In fact, her inquiry itself is illegal, my lord, in view of section 100 of the APTA order, section 31 of the APTA order, my lord.
It shouldn't be finally.
So section 52,
disposed of
53 is
minor,
not.
then these proceedings should be continued, my lord. If repetition is allowed, then it should come into this proceeding, my lord. Then finally, firstly, my lord, repetition be disposed of, my lord. It is succeed in the then this.
In that case, my lord, till disposal of the writ petition, your lordship may stay the proceeding at PRC case number 305 of 24, my lord. And I will submit the judgment before your lordship, my lord. Lordship, may I treat it as a part?
Yeah.
If they have raised such objections, my lord, since my lord, I have my role is not there, my lord. I have not present there, my lord.
Give me the writ petition.
Writ petition. That is my office copy, my lord.
But you have not challenged that
My lord.
search,
None.
search as such. You have prayed for washing of the collection memo.
Collection memo and my lord,
The original
restoration of my
documents should
shop.
be released.
My lord.
Hmm?
My lord.
You have not challenged that.
My lord. We have not challenged me. My lord, may I keep it on the record, my lord, if your lordship did. I keep that on the copy, my lord.
Was there any stay order in this?
No, my lord.
Because your
It
license
is admitted, my lord, for hearing, my lord.
But
And it will be
your
already hard, my lord.
Your this thing is not cancelled. License is not cancelled.
That is suspended, my lord. Worship, but in fact, that is, they have arrested me, my lord, after this, my lord. Sir, they have arrested me.
What, may submit that one.
Order passed on.
See, it will, Mr. Alam, that petition will have some bearing on this.
My lord.
Correct. It will be better that petition could be disposed of earlier.
My lord. In that case, your lordship may have kept it part hard, my lord.
No, keeping part hard is difficult these days. 1 month is only the only thing.
In that case, my lord, my humble submission, proceeding may be stayed, my lord.
No, that will. We have not considered this case as because this thing, I've gone through this. It will have some bearing on this case.
My lord. In that case, the petition may be disposed of, my lord, in the meantime. It may be disposed of this month, my lord.
We'll post it after 4 weeks.
My lord. Only prayer, my lord, your lordship may kindly stay the proceeding, my lord. Your lordship.
Till now, this has gone so far. Now at this stage, it will be difficult to take this.
No, my lord, that was time on technical ground. Since, my lord, that matter was hard.
Suppose you get it disposed first.
My lord.
Then your case will be easier in this case.
My lord.
Heard Mr. I. Alam, the learned counsel appearing for the accused, appearing for the petitioner. Also heard Mr. K. Vaishya, the learned recently for the state. Mr. M. Chepia, the learned appearing for respondent number 2. Respondent number 2, full stop. Let the matter be listed on agreement on our agreement of the parties. Let the matter be listed after 4 weeks.
My lord.
Take back your business. And please also take back.
Highly obliged.
We have wasted some time, but there is no other way. We have wasted our some time. Yes, there's no.
Please, your lordship. In this matter, lordship, I would like to file an additional affidavit to bring on some record. Since the trial is almost in the finishing stage, like on the next date is for the SD. Now the witnesses have already deposed, and when the trial court record was called for, it was already almost like 6 months back. So there may be a lot of developments that might have taken place and regarding the witnesses. So need to file an additional.
It's already on the verge of completion. Then why this petition is required to be?
No, only the fact is on 17th is that particular date. So if we can get a chance to at least place our case, because the witnesses have been examined, only 4 or 5 witnesses were there. So now it can be taken up that the witnesses already the witness evidence stage is finished. So at least we can bring that one. Since in this matter we have not been granted stay, that was the reason. So if lordship could permit us to at least file the affidavit and bring on record, and we can hear it before the next.
Otherwise, it is, my lord, what my learned friend submitted that, my lord, is SD, my lord, last stage, my lord, statement of defense only. And already all witnesses, my lord, were examined. My lord.
So what is the point of like keeping this pending?
Actually, your lordship, since we have a case actually in our hand.
Already it will be over in the trial court.
Yes. Only the if lordship will permit, then only, because of the fact that this matter was taken up in 2019. This particular trial court started. Then it took lot of time to start the trial. And when we actually approached this honorable court at that point of time, the witnesses had not happened, and there was a prolonged deal.
Now that the time has passed, the matter is going to be over there, but the trial is going to be over there. What will remain in this case then?
Since we had actually challenged the
yes, challenged it, but the trial is already going to be over. There is no stay.
There is no stay.
There is no stay.
Yes.
So trial will be over. What is the point of? keeping this pending?
At least one date, my lordship, just to file the affidavit.
You take one date, but I don't think there will be any purpose because the trial will
Yes,
be
yeah,
over.
on 17, if it happens, in the meantime, we will just file the affidavit since the petitioner
I heard
is.
Mr. W. or Medhi, the learned counsel appearing for the petitioner, also heard Mr. K. Boshia, the learned appearing for the state. Mr. Medhi submits that he would like to file an additional affidavit bringing on record certain documents relating to subsequent events in the instant case, full stop. Let the matter be listed after 3 weeks.
Yes, my lordship. Obliged, lordship.
None appeared for the petitioner when the matter was.
My lord, I am appearing on behalf of the respondent number 2, Chief Security Commissioner RPF. So in their allegation was that the accused was not examined under section 311(13) of the CRPC. But from the judgment of the railway magistrate, it is evident that accused was examined under section 330(13). So my lord, their question was cannot be maintainable. Moreover, my lord, after getting the judgment from the railway magistrate, they approached to the appellate court, and there in the appellate court also they have not raised this point. And moreover, under section 391, if there is any grievances, the accused was not examined under section 313, then they can approach the may submit before the appellate court, and appellant can remand back the matter to the railway magistrate for further examination.
Okay, no one is there, madam, today. That's all.
Yes, my lord.
So we'll give some time.
Yes, my lord.
Post it after 2 weeks.
Yes, my lord.
None appeared for the petitioner when the matter was called for. Though, MS, your name, madam?
I am Mrs. U. Chakraborty, Special Senior Railway Counsel.
Huh?
Mrs. U. Chakraborty.
U. Chakraborty,
Special Senior Railway Counsel.
Special Senior Railway Counsel for respondent number?
Number 2.
Respondent number 2 is present. Mr. Boyster also there? Mr. K. Boyster, the learned APP is present for the state respondent also. Let the matter be listed after 2 weeks.
But the date may fix, my lord. 18th June. No, no.
Let the matter be fixed on, then we'll put it on 25th of June.
25th of June. God bless you.
May I please, your lordship? My lord, I think Mr. D. Nath is appearing on the other side.
Yeah, he's on his.
Should we start? Can we start?
Yes.
My lord, this is a writ petition for clubbing of multiple FIRs based on the same transaction. This is a writ petition for clubbing of FIRs based on the same transaction, which were filed at 4 different police stations. And the scope of adjudication at this present form is confined to only prayer E at page 24. Malad, have this writ petitions, page 24, prayer E.
Yes. What you are saying?
Well, this is a writ petition for clubbing of multiple FIRs based on same transaction. Now the adjudication is confined to prayer E or at page 24 only. Prayer
What
E,
happened to the others?
my lord, these are all interim prayers, my lord. These were all interim prayers, my lord. So now because affidavits are pleadings are complete, my lord, and there is no stay. There is no stay in this matter.
Yes.
Yes, my lord.
the background of the accused, my lord, here is a private limited company which was imparting skill development training program through a single NIT. And there were tasks given to the petitioner to impart skill development training program in 4 districts, my lord. That entire training program was coordinated from Gauhati. Kindly have a.
You are ready, madam, you are ready.
No, I'm waiting for my senior sir to come and continue with this matter.
When he will come?
So he's on his way. He's on his way.
Yes.
Well, kindly have page 35. Well, page 35 is the first FIR and it is in vernacular. This was registered on 13/9/2022, the date of first FIR. I have given the pleadings, my lord, at.
Now, where is it? Where is it? Person?
My lord, page 33, my lord. Page 33.
Where is the content of the FIR?
My lord, the page 35, my lord.
35 is in vernacular.
Yes, my lord.
Where
I
is
will
the-
place that
where is
for
the
a
trans-
moment, my lord. I would like to place this particular. That is the English translation, my lord, which we have filed. My lord, it is at page
20.
English
Page
translation to
28.
28. My lord, page 28, my lord. Page 28. May I place it, my lord?
Yes.
We, the undersigned laborers residing within the jurisdiction of Rongia Police Station, have the honor to state with a heavy heart that an amount of rupees 80 crore was sanctioned to Ajitax Ventures Private Limited, Gargo Institute of Technology and Puberon to impart training to the laborers under Skill Training Pilot Project Phase 1, 2016-2019. Kindly mark Pilot Project Phase 1. This is the whole skill development program. But the 3 organizations prepared list of more than 20,000 fake laborers and beneficiaries, made fake photographs and videos of imparting training to the laborers and received the entire money for imparting training for 2 months just by imparting training to the laborers for 2 or 3 days and misappropriated the entire money. The organizations also received money in the name of providing food to the laborers for the entire training period by submitting fake bills and misappropriated the money. They deprived the laborers undergoing training from certification and government stipend. Ajitax Ventures and Gargo received an amount ranging from 25,000 to 27,000 against every laborer in the name of imparting training to the laborers. Besides, the organization received money in the name of providing food to the laborers by submitting fake bills and also received rupees 50 from every laborer in the name of registration. The organization deprived every laborer from for an amount of rupees 16,800, that is 35 per hour, 8 hours daily for 60 days, rupees 280 into 8 into 50 equal to 16,800. The project was completed by giving 16,800 to some of the laborers. We therefore earnestly pray to your good self to be kind enough to investigate the matter, to ensure punishment to the culprits and to ensure the laborers get their dues and obliged. This is the contents of the first FIR.
Yes.
Why I was my lord, keen to place the FIR in vernacular, my lord, because the way it has been drafted and basically the 3 FIRs, my lord, are verbatim the copies of the first FIR in vernacular. And my lord, the complainant here, my lord, will kindly peruse, my lord, at page 35.
Your translation is not complete.
No, my lord. My lord, the translation, my lord, I have pleaded in page.
No.
There was,
Your translation of the FIR is not complete.
yes, my lord, there is some,
It's incorrect.
yes, my lord. Yes, my lord, I have gone through.
Place this before the.
Therefore, my lord, I was keen to place that vernacular, and I have also.
Different thing, but like once a translated copy is there, nobody is, who is going to read this vernacular?
My
May
lord,
not be other judges may not be able to do.
my lord, my
I
lord,
mean, now the translation copy that you have submitted
my lord,
is incorrect.
my lord, at page 7, my lord, I have stated, my lord. At
But
page
about
7,
that, like, I mean, why you have given a wrong translation?
Lord, at the time of filing, my lord, there was some difficulty.
What difficulty is that?
My lord, it was my mistake, my lord, my mistake. I have pleaded, my lord, at page 7, my lord, may kindly have para 4. This is the correct translation, my lord. The allegations I have summarized at para 4, my lord.
Yes, then thereafter.
My lord, thereafter, my lord, this FIR was, my lord, transferred to Rongya police station. To this FIR was transferred to Rongya police station, my lord. My lord, may kindly have page 55. Page 55, my lord. Dispur. My lord, has it, my lord?
Yes.
Dispur PS case 2098, 29/10/2022. Case record is put up today on the strength of a prayer made by the IO so-and-so for transferring the case from Dispur police station to Rongya police station. Heard perused, it is submitted by the IO that the investigation of the case is to be conducted at Rongya, since it is revealed that nothing relating to the subject matter of the case concerns itself with Gauhati. Peruse the case record as well as case diary. Prayer is allowed. GR branch is hereby directed to hand over the original FIR and other documents submitted, if any, to the IO. Necessary endorsements may be made by the GR register. But now, Dispur was transferred to Rongya. Thereafter, my lord, and on subsequently, a second FIR was also registered at Rongya police station, a different FIR, my lord, and eventually the Rongya was also transferred on the same day to Dispur on 29/10/2022. I will come to that, my lord. My lord, may kindly see have page 65. What is the English translation?
What is it?
My lord, English translation is page 56, my lord. And the Rongya police station FIR starts at page 63. 63 is the formal FIR. And my lord, 65 is the letter of complaint.
$65 is in vernacular, right?
Yes, my lord.
And where is the translated?
My lord, this is at page 56.
56.
Yes, my lord. 56.
Yes.
We, the undersigned laborers residing in the jurisdiction of Rongya police station, have the honor to state with a heavy heart that amount of 80 crore was sanctioned to Ajitag Ventures Private Limited, Gargo Institute of Technology, Kuberon, for imparting training to laborers under skill training pilot project phase 1 2016-19. But the three organizations prepared list of more than 20,000 fake laborers and beneficiaries, made fake photographs and videos of imparting training to the laborers, and received the entire money for imparting training for 2 months just by imparting training to the laborers for 2 or 3 days, and misappropriated the entire money. The organizations also received money in the name of providing food to the laborers for the entire training period by submitting fake bills and misappropriated the money. That the three organizations opened training center within the jurisdiction of Rongia police station in Kamrup district like they did all over Assam. It is painful to show that Mongoldoi too, the organization impart training to the laborers. At Mongoldoi too, the organization imparted training to the laborers for 2 or 3 days instead of imparting training for 60 days, received an amount of 16,800 against every laborer in the name of providing lunch for 60 days and an amount of 150 per day against each laborer in the name of communication of the laborers to and from the training center for 60 days by submitting fake registration certificates to laborers and fake bills for food, and thus cheated many laborers of Mongoldoi and misappropriated their money. They deprived the laborers undergoing training from certification and government stipend. Aditax Ventures and Gargo Institute received an amount ranging from 25,000 to 27,000 against every laborer in the name of imparting training to laborers. Besides, the organization received money in the name of providing food to the laborers by submitting fake bills and also received rupees 50 from every laborer in the name of registration. Organization deprived every laborer from an amount of rupees 16,800, that is 35 per hour, 8 hours daily for 60 days, 280 into 8 into 50 is 16,800. Project was completed by giving 16,800 to some laborers. This is the contention raised in the allegation against this in the second FIR. Now this second FIR on the same day was again transferred to Dispur. My lord, kindly have page. Yes, my lord, kindly have page 69. Page 69, my lord. This is Rongia PS case 596, my lord. And the top, my lord. CR is put up before me today. Seen prayer of Samarjyoti Deka of this instant case of Rangia police station as well as Perus the same. The prayer is made for passing an order to transfer the instant case to Dispur PS, stating that during investigation it has come to light that the place of occurrence of this instant case falls under the jurisdiction of the said PS. Peruse the CR as well as case diary placed before me. As such, considering the facts stated, prayer of the IO is allowed. Transmit the case records to the OC Dispur for his needful doing. OC Rongia PS is asked to hand over the case diary as well as other articles related to the case to the OC Dispur PS. Inform accordingly. And my lord, may kindly mark the date. It is 29/10/2022. At the left hand side, my lord. First column, 29/10/2022. And my lord, may kindly once again revisit page 65, my lord. 55, my lord. 55. That was also on 29/10/2022. Now, both these cases, my lord, were transferred from their respective police stations to one another, my lord. Dispur transferred to Rongia. On the same date, Rongia transferred to Dispur. And my lord, eventually, what we came to learn from the opposition, my lord, filed by the state, and now, as it stands today, my lord, Rongia PS has again retransferred the case to Dispur.
The other one.
The first FIR, my lord, which the Dispur initially transferred to Rongia. Rongia, my lord, once again has retransferred the case to Dispur PS. My lord, may kindly have.
The cases are now pending in Dispur.
In Dispur, my lord. Now these are the two cases, my lord. My lord, there is a third FIR, my lord. Now I will come to the third FIR. My lord, may kindly have page 74, my lord. Where is the formal? The formal English translation is at page 70, my lord. This is Tihu PS, my lord. Tihu police station case. The formal FIR is at page 74, my lord. And the letter of complaint in vernacular is at page 78.
The same contents.
Yes, my lord. Same word to word, my lord. Same contents. And my lord, there is a fourth FIR, my lord. Fourth FIR. My lord, kindly have page,
This is pending in TU. It is not
pending in Tihu, my lord.
not transferred.
It's not transferred, no, not anywhere, my lord. And my lord, there is a fourth FIR, my lord, at page 88, my lord. Not 88, this is Dhula. Yes, it starts at page 88, my lord. The English translation is at
84.
page 84, my lord. Again, the contention, calculations, allegations, everything same, my lord. Verbatim.
This is before Mongol Day.
Yes, this is before, initially it was filed before Mongol. Then, my lord, Mongol transferred it to Dhula police station. Now, my lord, as of now, the case is registered at Dhula police station, my lord. The formal FIR, my lord, at page 88, registered as Dhula PS case number 268. So, my lord, these are the 4 FIRs, which is pending investigation. And, my lord, the only test to be satisfied, my lord, is the test of sameness. Whether the allegation relates to the same transaction and it satisfies the test of sameness. And the prayer, my lord, relief sought, my lord, is limited only to the ground that all these FIRs may be clubbed together, brought under one single police station, and there can be an investigation. More importantly, my lord, before the Dispur police station,
Now of the investigation.
my lord, it is
Is the stage of investigation.
pending investigation, my lord. To the best of my information, the charge sheet has not been filed.
Is there any stay?
No stay order, my lord. No stay.
Lordship,
No stay. Charge sheet has still not filed, my lord. In any of the cases.
That's not filed.
Yes, my lord.
Lord, considering pendency of this matter, my lord, the Honorable Court has directed us to produce the case diaries. We have taken the case diaries. Lordship has directed to keep the case diaries. As the case diaries are here, they are not in a position to proceed in the matter. The case diaries are with us, my lord.
Now, my lord, there are a few other admissions, my lord, which has come up in the opposition which has been filed by the state respondent, my lord. My lord, so far as the case registered at Dispur is concerned, my lord, they were also residents from Baihata Sariali, my lord. From Baihata Sariali, wrong, my lord.
Who are the residents of Bahar side?
My lord, the complainants which initially filed the first FIR. Those who have filed the first FIR before the Dispur police station, my lord, they were residents of Baihata Sariali and a nearby area of within Kamrup rural, my lord. Now they are not residents within Dispur police station, my lord. And the training also, my lord, did not happen within the jurisdiction of Dispur police station. The head office is, of course, located within the vicinity of Dispur police station of the training provider, my lord. And they lodged a complaint before the Dispur police station. Subsequently, Rongia also, my lord, the residents, local residents from Mongoldoi and Rongia came to Rongia police station and lodged the FIR. And having done a substantial part of the investigation, my lord, the case was transferred to Dispur, saying that we don't have anything within our jurisdiction and let this matter be investigated by Dispur police station. So Rongia transferred the matter to Dispur, my lord. But the residents, the complainants are from Rongia and Mongoldoi, my lord. None of the complainants are from Dispur. They are residents of Mongoldoi and Rongia. The third FIR, my lord, which is Tihu, my lord. In Tihu also, my lord, there are complainants which are residents of 2 different police stations. Patar, some, yes, one is under Tihu police station and another is Patasar Kuchi police station, my lord. So 2 different police stations, my lord. The residents came together, filed a police and the training, my lord, which had been conducted so far as Mongoldoi complainants are concerned. The training center was located at not Dhula. Well, not in Mongoldoi, my lord, and some other area, my lord. Not within the domain and jurisdiction of Dhula police station, my lord. Why it was transferred, we do not know. because on the basis of the residential address of the complaint, some of the complainants, my lord, those were transferred to Dhula. Now, be that as it may, my lord, the test of sameness, if it is satisfied, my lord, so we have brought some additional documents in form of additional affidavit, my lord, to satisfy the test of sameness in this case, my lord, whether this can be treated as a same transaction. My lord, for that, we have filed an additional affidavit. My lord, may kindly, before I come to the additional affidavit part, kindly.
How can it be a same transaction? Because there are trading systems, different trading systems are.
Yes, my lord, that is why I am coming to that, my lord. My lord, may kindly have page 94, my lord, of the opposition, my lord, filed by the state respondents.
94.
Yes, my lord.
'94 is something else.
My lord, 94 of the opposition, my lord. 94 of the opposition, paragraph 3, Roman 1.
The continuation page 94 is.
Oh, my lord, I think the copy at that point of time, there was continuation as you know, sir. Okay.
You should check it out. I mean, now continuation page is something else. How will you refer to?
My lord, may kindly have internal page.
The internal page is not there.
Internal mark, I think the 3 mark was internal. It is starting from
on when?
Right.
Affidavit in opposition by whom?
My lord, it was filed on 16 September, my lord. Affidavit by the state, my lord.
Respondent numbers.
Position, respondent, state respondents, my lord. Respondent number is respondent number 1 to 6, my lord.
Filed by Nitul Gogoi, my lord, on 20 September 2023.
I can find affidavit in opposition by respondent number 7, 9, and 10.
7 has filed later on.
Additional affidavit to do.
It's not September 23.
আমার repetition আসলে basically last 91, 92. And you're starting at page 93. कोई होगा ना मुझे मैं तो strong होता है ठीक है.
Is it by Nitul Gogoi?
Yes.
Yes. This page 130.
Yes, my lord, may kindly have page 131. 131, para 3, Roman 1, Dispur PS case and Rongia PS case. And so far as the contention raised by the state, my lord, My lord, may I kindly turn to the next page, page 132.
Yes.
Last para, my lord, F. That as regards to the statement made in 111 to 42 of the repetition, deponent has no comments to offer. The deponent further begs to state that the contents of both the FIRs, dispute and case number 2098, first FIR, and Rongia, case number 59622, second FIR, are based on the same cause of action, having same place of occurrence, but the complainant belong to different parts of the state. Since FIRs fall under the district of Kamrup Metro at Gauhati, hence both the FIRs have been transferred to its original place of occurrence, that is dispute, with all the documents and case diaries. So far, these two cases are concerned, my lord, but the training was never imparted within the jurisdiction of Dispur police station, my lord. Those training at all centers happened at different locations and not under Dispur police station, my lord. And my lord, so far as third FIR is concerned, my lord, kindly have page 133, 133 at paragraph 3B, last para, my lord, that as regards to the statements made in paragraph 2B of the repetition, the deponent begs to state that the complainant received in the instant case was registered as FIR at Tihu police station, why Tihu police station case number 100 of 22 under section so and so, as the complainant alleged commission of cognizable offence committed at village Namatari, Paramankhwa, which falls within the jurisdiction of Tihu police station. That this is important, my lord. As regards to the statement in paragraph 2E of the repetition, the deponent begs to state that the complainant did not disclose the fact that FIRs have been previously registered at different police stations regarding the same incident event. The officer in charge of Tihu police station hence was not aware of such registration of multiple successive FIRs. My lord, the same incident oblique event, my lord, may kindly mark.
Yes.
My lord, next at para E, my lord. Para E, last three lines. The officer in charge Tihu police station at the time of registration of FIR was not aware that multiple FIRs have previously been registered at different police station with similar letter of complaint. So, my lord, these are the admissions, my lord, which goes on to show that this writ petition clearly complies with the test of sameness, my lord. So far as the 4 different FIRs are concerned.
Dhula.
Yes, my lord. So far as Dhula is concerned, my lord, Dhula also, there is no categoric admission as such, which was there in Tihu and Rongia and Dispur. But we can draw an analogy, my lord, because the complainants in Dhula are from Mongoldoi and the complainants at Rongia, my lord, originally also were from Mongoldoi. And my lord, from the complainants in Dhula are also Mongoldoi, therefore, at now, my lord, at page 4, page 136, my lord, page 136, paragraph 4, and this is again, my lord, a stand which is mutually destructive, my lord, so far as the earlier 3 FIR and Dhula FIR is concerned. Paragraph 4, my lord, may I kindly place it, my lord, that the deponent states that in the present case, different people have alleged to have been defrauded by the petitioner and therefore the offences are of difficult nature and cannot be regarded as constituting a single series or facts oblique transaction. Each of the FIRs were registered for the specific offences of fraud and misappropriation of money of different persons, and it gave rise to not only one but more cognizable offence against different people at different place and different time. My lord, this pleading, my lord, in my humble submission, my lord, is contrary to the stand which was taken so far as Rongia, Dispur, and another Tihu police station is concerned, my lord. Therefore, though broadly the offences as alleged in the FIRs are similar, those are distinct and separate offences. Therefore, registration of the FIR as mentioned above and the investigation therefore is proper and the same is valid. So, my lord, these are contrary stands which has been taken by the state respondent, because according to this para 4, each FIR, my lord, is a distinct FIR. Had that been, my lord, a case, then Rongia and Dispur ought not to have been clubbed together. And that was done by the state itself. And so far as Tihu is concerned, my lord, there is a categoric admission with regard to the test of sameness, that these belong to the this regards with regard to the same allegation. Now, my lord, to satisfy further, my lord, we have placed some documents in form of additional affidavit. Page number. For us. Now, this additional affidavit was filed on June 2024. Date clear than I don't. Where is the date? My lord, at page, it starts with page 186, filed on 6 2024. The lordship has it. My lord, may kindly have, this is the page 190 is the RFP. Page 190 is the RFP, which was for phase 1, which is common in every allegation, my lord. Pilot project phase 1. This is the common allegation, which was common program, which has been referred in all 4 FIRs, my lord. And this is the RFP. My lord, may kindly have page 201. Page 201, section 2 of the RFP. Yes. Paragraph 2, my lord, necessity of the assignment to impart skill training and upgradation of skill where necessary to the registered workers and their dependent children and spouse. Scope of the work, the skill upgradation initiative is to envisage primarily as a work site led training. My lord, may kindly mark this is work site led training. Intervention considering the accessibility element considered vital to the construction sector, important for participation of workers, and also the relevance in providing best in class industry endorsed training. The training partner shall anchor tie-ups with various industry partners, real estate companies, infrastructure companies, etc., and establish training centers at their work sites to facilitate assessment and training of the current workforce. Identification of the work site. The number of unskilled and semi-skilled learners, workers should be more than 100 across the trades in a typical work site. So, my lord, the moment it crosses a substantial number, then there is a different training center. There is a cluster of such sites envisaged in each city public region that will be supported by a project management team from the training provider. And my lord, may kindly turn now to page 203. 203. Your lordship got it, my lord? 203. My lord, in between, my lord, the paragraph, and in between it starts with beneficiaries. Beneficiaries would be shortlisted during preliminary interviews before putting them on assessment. During preliminary interviews, they would be asked few questions relating to their trades. Based on the outcome, the beneficiaries could be sent for assessment or further training to upgrade their skills. So the beneficiaries after interview can be sent to any of the work sites.
Yes, what do you want to show from this?
Yes, my lord. So far as the commonality of management is concerned, this is the thing, RFP, which shows that there is a commonality of management.
RFP only.
My lord.
There was only one RFP.
Yes, my lord. Single RFP.
Single RFP and like these two persons, that Sarkar and other person.
Yes, my lord.
Both of them participated.
My lord, no, my lord. There are two agencies. One is Gargo and Ajitax.
One is Gargo and one is
Ajitax, my lord.
Uh-huh.
We are Ajitax, my lord. Gargo is not here.
Not here.
We are Ajitax, my
So
lord.
you own how many of these things?
Training centers, my lord. Yes, my lord. I am coming to that. My lord, may kindly have
in the RFP.
Yes, my lord.
In the RFP, how the participation was made?
The participation was made through tendering process, my lord.
Was
We
it
participated.
divided to certain district wise or what?
That is what I am showing, my lord, at page 212. There is a document to that effect. What my lordship is asking, my lord, page 212. This is the letter of intent. And my lord may kindly see, this has been addressed to Puberun Consortium of Companies. And
So
just
Puberun Consortium includes you?
Yes, my lord. Puberun Consortium of Pragati EduTech, Trisha Construction and Ajitax Ventures. And Ajitax Ventures was the lead partner, my lord. Here, consortium was allowed. And my lord, first paragraph, with reference to the subject cited above, we are pleased to award the work of service provider for skill development of the construction workers and their dependents in various districts of Assam as per the following terms and conditions. My lord, may kindly have 213. Turn to the next page, 213. Now, third column, my lord, number of proposed districts. My lord, may kindly see number of this is Nalbari, Kamrup Metro and Mongoldoy. And my lord, these are the job roles and the total allocation was 6,300.
What, 6,300 what?
6,300 workers, my lord. Trainees, probable trainees. And this was, my lord, not generic to each and every district. 6,300, my lord, was 6,300, my lord, was not allotted distinctively to each of the districts, my lord. My lord, this was a cumulative order, my lord, for all 4 districts together to be managed by the training provider from site to site basis as per requirement. And my lord, kindly have 214 for non-residential courses. Your lordship has it, my lord? 214. Now, my lord, 2 variable cost down below, variable cost. Paragraph starts with variable cost. Apart from the above mentioned fixed costs, the board will pay rupees 35 per hour to the eligible trainees during the training period. For this, wage bill will be paid on weekly basis to the service provider on submission of attendance proof of the beneficiaries, which will be validated by the consultant. Well, the consultant is a third-party agency. Further, for the women trainees who will need to travel at least 80 kilometers, well, this is important, who will need to travel at least 80 kilometers from their home to the training center, rupees 2,500 per month will be paid towards transportation allowance. For this too, the service provider has to submit adequate proof to claim such bill. So, my lord, the distance of 80 kilometer, my lord. So it is not.
What is your issue? I mean, issue is what in this petition? I mean,
issue is, my lord, there are multiple.
It will matter.
Yes, my lord, there are multiple FIRs which has been lodged in 4 different police stations. Now 2 of the FIRs are standing in Dispur police station for investigation. Tihu and Dhula, my lord, may be transferred to Dispur police station because the original FIR, my lord, was before the.
Well, in fact, well, in paragraph 4, we have said that.
These are similar, you have said.
No,
one paragraph you say, I mean, couple of paragraphs you have stated that these are similar nature, 3 cases. That has come in your affidavit.
No, this has.
Again, in 4th paragraph, you are saying that no, I mean, they are distinct and whatever.
No, that has been not read properly. But in fact, page 134, paragraph C,
which my learned friend has read, that is in response to his paragraph 2E. In 2E, my lord, we have denied paragraph 2E of the writ petition. In response to that, that was the statement made. It is not an admission from our side. Kindly see what.
No, let us see what we have replied.
Lordship. Kindly see, my lord, first at page number 7 of the writ petition, what they have said in paragraph number 2E. To para 2E only we have responded.
Paragraph 2 is like registration of multiple successive.
Yes, Lord. They said that registration of multiple successive FIRs by different police stations in different parts of the state of Assam without stating the material particulars of various complaints in gross violation of the mandatory provisions relating to the registration of an FIR. So that was the statement made by the petitioner.
Let us see the answer.
In that, my lord, as regard the statements made in paragraph 2E of the writ petition, the deponent begs to state that the complainant did not disclose the fact. Complainant did not disclose the fact that FIRs have been previously registered at the different police stations. And regarding the same incident event, the officer in charge to
which paragraph? You are reading from where?
I am reading from page number 134.
34.
C.
134.
C, Malad. C. We have said that as regard the statements made in paragraph 2E of the writ petition, the deponent begs to state that the complainant did not disclose the fact that FIRs have been previously registered at different police stations regarding the same incident event. The officer in charge to police station hence was not aware of such registration of FIR.
Correct, there is
multiple FIRs.
But what about the other statements you have?
Lordship. Then in paragraph E, Malad, it is in response to their paragraph number 12. Kindly see, Malad. In the writ petition para 12, they have said the petitioner states and submits that from a bare perusal of the aforesaid letter of complaint dated 14/10/2022 filed with the respondent number 8, it is once again evident that the allegations contained in the said letter of complaint is the exact verbatim of the same allegation as contained in the aforesaid letter of complaint dated 13/9/22 and 26/9/22 filed by the respondent number 6 and 7 respectively as aforesaid. But we have said in response to this, we have said that as regard the statements made in paragraph 12 of the writ petition, the deponent begs to state that the case under investigation and is pending. This is in respect of Tihu. Investigation and is pending because the accused did not join the investigation even after being served notice under section 41A of the CRPC. The officer in charge Tihu police station at the time of registration of the FIR was not aware that multiple FIRs have previously been registered at different police stations with similar letter of complaint. We have said that why the Tihu police station case was registered. Despite receipt of section 41 notice, the petitioner did not cooperate. That is why the the FIR was registered at Tihu. Then, Malad, we have said, finally, you have said that ultimately, kindly see the persons who the centers are at different place and the persons who were defrauded, they belong to different places. Therefore, we have said, Malad, that the present case, different people have been alleged to have been defrauded by the petitioner, and therefore the offences are of difficult nature and cannot be regarded as constituting a single series of facts transaction. Each of the FIRs were registered for the specific offences of fraud and misappropriation of money of different persons, and it gives rise to not only one but more cognizable offences against different people at different places and different time. Although the works are under one scheme and the petitioner, the consortium was given the work, they have different centers at different places. And see, kindly the Dhula police station case, the center, it is mentioned, Mullah, at page 136, Mullah. Page 136, the para starts as, during investigation, it has been revealed that the place of occurrence, that is Sarkar Chowk, falls under Dhula police station. Accordingly, IO submitted a prayer before the jurisdictional court bring the case to Dhula police station, and the same has been allowed by the learned court. So Dhula police has to investigate that what has happened at Sarkar Chowk. Who are the persons affected? Who are the defrauded there?
But why then like Dispur case, Rangya case has been clubbed together? All transactions happen in Dispur. all offences committed in dispute.
But after investigation, preliminary investigation, they found that the place of occurrence does not fall within the jurisdiction of Rongia police station. And therefore, the FIR was transferred to Dispur police station. We have stated at page 132, Malad, para D.
So that's why Rongia case was transferred to Dispur.
To Dispur.
Dispur was again transferred to Rongia.
The Dispur was one of initially it was sent, but finally it was again sent to Dispur because the addresses of some of the persons were from that place. That is why it was sent to them, that place, but subsequently it was taken back to Dispur Malad. Both the affairs are now at Dispur Malad. Therefore, para F, Malad, page 132, para F, we have said. The deponent further begs to state that the contents of both the FIR's Dispur PS case number 2098 of 22, the first FIR, and the Rongia PS case number 596 of 22, that is the second FIR, are based on same cause of action, having same place of occurrence, but the complainant belong to different parts of the state. Since FIRs fall under the district of Kamrup Metro at Gauhati, hence both the FIRs have been transferred to its original place of occurrence, that is Dispur.
We do not know whether Rongia is under Kamrup Metro. That I seriously doubt. That Rongia falls under Kamrup Metro.
No, it is not. That is good. It is sent to the place of occurrence.
According to them, Rongia is under Kamrup Metro. So therefore, it has been transferred to Dispur. I'm not sure whether Rongia still falls under Kamrup Metro because to the best of my knowledge, it is Kamrup Rural.
That's true. That's true. We have said that the cause of action having same place of occurrence, but the complainants belong to different parts of the state. Since the FIRs fall under the district, FIRs fall under the district of Kamrup Metro.
Yes.
The place of occurrence. Therefore, hence both the FIRs have been transferred to original place of occurrence, that is Dispur police station. Don't pick one sentence from here and there and then make submissions.
Since FIRs fall under district Kamrup Metro, my lord, FIRs would mean include Rongia. So I am saying, my lord, the Rongia FIR falls under Kamrup Metro. This is the plain literal interpretation of the sentence, my lord. I am only speaking one sentence. Since FIRs would include two FIRs, my lord. Since FIRs fall under district of Kamrup Metro, so they mean to say Dispur police station and Rongia police station FIRs fall under Kamrup Metro. Hence, the sentence starts with since and followed by hence. So conjoint reading of both the parts of a single sentence, my lord, would lead to a conclusion that both the FIRs fall under district of Kamrup Metro. This is what they have stated, my lord.
Kindly read the previous sentence to that, my lord. Based on the same cause of action, having same place of occurrence, therefore both have been transferred.
Yes. And my lord, that would also lead to a violation of Article 14 because residents and complainants from Rongia would be treated differently, my lord. Their case will be investigated by Dispur police station.
I don't think that.
And the complainants from Tihu and Dhula will be investigated by the respective police stations.
My friend is not espousing the cause of
because
people of
the
Rongia.
people of Rongia police station, if they are transferred to Dispur police station for investigation,
How does it prejudice you?
my lord, I am facing multiple FIRs.
How does it?
No problem. Yes, my lord. Absolutely not, my lord. I will join investigation in 4 different police stations. I will give the same documents in 4 different police stations, whatever it may be. But the stand taken by the state, my lord, at this present form, my lord, because the residence and training center still exists in Rongia, and their case has been transferred to Dispur police station at the behest of the state. It was not on my behest that the case was transferred from Rongia to Dispur. And my lord, the test of sameness, I have Supreme Court judgments, my lord, to that effect, that if it is the test of sameness has to be applied, my lord, respectfully, my lord, the test of sameness has to be applied. And if the court is satisfied that the test of sameness is applicable in this case, then the registration of multiple FIRs is not permissible, my lord. I have judgments to that effect. I would like to place reliance on those judgments, my lord, if my lord permits.
Your stand is that only.
Our stand is that because in these are not, this is not a case that where a person has made some public speech and aggrieved persons one at some incident occurred at one place and at various places some different affairs are being lost. Those were clubbed. This is a particular offense. This is a financial fraud. This is an offense committed at various places to various affected persons. This cannot be.
But basically, this is a government scheme, right?
This is the government scheme.
Government scheme, and like this is basically they are to train these unskilled people, to give them some scheme.
Lot.
Correct. The Amazons and all these people, carpenters and all. So the money is basically spent from the state exchequer.
Yes.
And there is nothing, no fees is taken from them, right? No. The only demands of these people are that they filed this affidavit, I mean, this FIS saying that there are some
Stipend and food bill was not paid. Yes.
And is there any scheme of stipend?
Yes, my lord. Kindly have 230. That is why, my lord.
Tell me what is that stipend?
My lord, so far as the stipend and the calculations which are stated in all 4 FIRs, my lord, 1600, 800 and food bills and all. My lord, there is
some allowances there, food
my lord,
is there,
my lord,
something is
my
there.
lord, my
Okay.
lord. There is
They were given some stipend also.
my lord.
Now thing is that like they have brought in certain people who have not been trained at all. The fake faces, right?
That is one part of the allegation that
No, that is one of the
20,000
allegations.
beneficiaries were
So you
created.
have siphoned of the money. Are you saying that like you have paid those people, but like you have not paid those people? That is the allegation.
Stipend.
Right?
We have misappropriated the stipend amount.
Stipend amount and other amount also. I mean,
Yes, yes, my lord.
You have, 1650 rupees you have taken for food, something, all these things.
Correct.
So ultimately, the allegation is that some misappropriation of the state money.
20,000 fake.
And you were supposed to give training for 30 days, but you have given only 3 days. And you have shown that I have given training to 30 days.
My lord.
So accordingly, you have misappropriated money.
My lord.
And this whole training has been done by you only.
Yes, my lord.
Correct. Nobody else is involved.
Yes.
You have different training centers because they cannot travel to different places. So in Shivsagar district there may be one, Darang district there may be one, different places. So ultimately, what you have done, like you have cheated people in Shivsagar also. You have cheated people in Darang also. There is allegation I'm saying.
My lord. My lord.
In Darang also.
My lord.
So Darang people have filed an FIR. Shivsagar people have filed an FIR.
My lord.
Now you are saying that okay, like these are all similar kind of. Not that I have committed. Those are similar. So we should be treated in one place only. That is your contention.
No, my lord. There is a specific document for which I have filed official.
Nothing else.
No, my lord. So far as the misappropriation.
See, the fraud I have committed in maybe in separate places, but thing is that now the separate FIRs have been filed in a similar line. So treat all those FIRs together, club it together, and
My lord, that is the law.
So state has to do as per your convenience.
My lord, that is the law as it stands today, as per Supreme Court judgments, my lord. And my lord has raised a very pertinent question, my lord. So far as the payment.
The Supreme Court law is so me that.
Yes, my lord. My lord, before.
You show me the Supreme Court
yes,
law.
my lord.
What Supreme Court says?
They to TT Anthony.
Let us see what Supreme Court has said. You have given some case laws here. Some cases are here.
You might have been given earlier, my lord.
Give me the name.
Well, TT Anthony. No, this is the first law.
TT Anthony, yes.
Yes, first judgment, my lord.
Yes.
Yes, my lord. My lord, may kindly come to each.
Paragraph?
My lord, paragraph 18.
18.
Yes, 18.
Yes.
An information given under subsection 1 of section 154 is commonly known as first information report, though this term is not used in the code. It is a very important document, and as its nickname suggests, it is the earliest and first information of a cognizable offense recorded by an officer in charge of a police station. It sets the criminal law in motion and marks the commencement of the investigation, which ends up with the formation of opinion under section 169
or 170 CRPC as the case may be, and forwarding of a police report under section 173 CRPC, it is quite possible, and it happens not infrequently, that more information than one are given to a police officer in charge of a police station in respect of the same incident involving more or one or more than one cognizable offense. In such a case, he needs to enter every one of them in the station house diary, and this is implied in section 154 CRPC. Apart from a vague information by a phone call or a cryptic telegram, the information first entered in the station house diary kept for this purpose by a police officer in charge of a police station is first information report, FIR, postulated as by section 154 CRPC. All other informations made orally or in writing after the commencement of the investigation into the cognizable offense disclosed from the facts mentioned in the first information report and entered in the station house diary by the police officer, or such other cognizable offenses as may come to his notice during investigation, will be the statements falling under section 162 CRPC. Now let me kindly mark this.
Yeah, this is very clear. We all aware of this. We are aware of that. Go on.
No such information statement can properly be treated as an FIR and entered in the station house diary again, as it would affect to be a second FIR, and the same cannot be in conformity with the scheme of the CRPC. Now next, paragraph 20, placitum H.
You go on reading. Take a case where.
Take a case where an FIR mentions cognizable offense under section 307 or 326 IPC, and the investigating agency learns during the investigation or receives fresh information that the victim died. No fresh FIR under section 302 IPC need be registered, which will be irregular. In such a case, alteration of the provision of law in the first FIR is the proper course to adopt. Let us consider a different situation in which H, having killed Y, his wife, informs the police that she is killed by an unknown person, or knowing that W is killed by his mother or his sister. H owns up the responsibility, and during investigation the truth is detected. It does not require filing of fresh FIR against H. The real offender, who can be arranged in the report under section 173(2) or 173(8) CRPC, as the case may be. It is of course permissible for the investigating officer to send up a report to the magistrate concerned even earlier that the investigation is being directed against the person suspected to be the accused. The scheme of CRPC is that an officer in charge of a police station has to commence investigation as provided under section 156 or 157 CRPC on the basis of entry of the first information report on coming to know of the commission of a cognizable offense. On completion of the investigation and on the basis of the evidence collected, he has to form an opinion under section 169 or 170 CRPC, as the case may be, and forward his report to the magistrate concerned under section 173(2) CRPC. However, even after filing such a report, if he comes into possession of further information or material, he need not register a fresh FIR. He is empowered to make further investigation normally with the leave of the court, or where during further investigation he collects further evidence, oral or documentary, he is obliged to forward the same with one or more further reports. This is the import of subsection 8 of 173 CRPC. From the above discussion, it follows that under the scheme of the provisions of section 154, 155, 156, 157, 162, 169, 170, and 173 CRPC, only the earliest of the first information in regard to the commission of cognizable offense satisfies the requirement of section 154 CRPC. Thus, there can be no second FIR, and consequently, there can be no fresh investigation on receipt of every subsequent information in respect of the same cognizable offense or the same occurrence or same incident giving rise to one or more cognizable offences. On receipt of the information about a cognizable offence or an incident giving rise to a cognizable offence or offences, and on entering the FIR in the station house diary, the officer in charge of a police station has to investigate not merely the cognizable offence reported in the FIR, but also other connected offences found to have been committed in the course of the same transaction or the same occurrence, and file one or more reports as provided under 173 CRPC. Next, my lord, may kindly have para 27 of the same judgment, because this is the judgment which has been followed subsequently, my lord, by all later judgments.
This is not the same transaction.
My lord, I will come to that. That has been explained in Babu Bhai, my lord, subsequent judgments.
Page 20, para 27.
Para 27, my lord. This is the parent judgment which has been followed till date 26. I have got a latest judgment, my lord. A just balance between, my lord has para 27. A just balance between the fundamental rights of the citizens under Article 19 and 21 of the Constitution and the expansive power of the police to investigate a cognizable offence has to be struck by the court. There cannot be any controversy that subsection 8 of section 173 CRPC empowers the police to make further investigation, obtain further evidence, both oral and documentary, and forward a further report or reports to the magistrate. In Narang case, it was, however, observed that it would be appropriate to conduct further investigation with the permission of the court. However, my lord, this is important. The sweeping powers of the investigation does not warrant subjecting a citizen each time a fresh investigation by the police in respect of the same incident giving rise to one or more cognizable offences consequent upon filing of successive FIRs, whether before or after filing of the final report under section 173 CRPC. It would clearly be beyond the purview of section 154 and 156 CRPC, nay, the case of abuse of the statutory power of investigation in a given case. In our view, a case of fresh investigation based on the second or successive FIRs not being a counter case filed in connection with the same or connected cognizable offence alleged to have been committed in the course of the same transaction, and in respect of which, pursuant to the first FIR, either investigation is underway or final report under 173(2) has been forwarded to the magistrate, may be a fit case for exercise of power under section 482 or under articles 226, 227 of the Constitution. So these are only under the inherent powers which we can address, my lord. This is the first judgment, my lord, parent judgment. Now, TT Antony has been followed subsequently in Babu Bhai, my lord. I think Babu Bhai was placed earlier in 2010 12 SCC 254.
One second.
My lord, may kindly excuse me for a moment.
Yes, yes. Yes, Babu Bhai is there.
My lord, may come to page para 20, my lord. Babu Bhai, para 20. At para 15, TT Antony was referred. Para 15, Babu Bhai. Following TT Antony, my lord.
Yes, para 20.
Para 20. Thus, in view of the above, the law on the subject emerges to the effect that an FIR under section 154 CRPC is a very important document. It is the first information of a cognizable offence recorded by the officer in charge of the police station. It sets the machinery of criminal law in motion and marks the commencement of the investigation, which ends with the formation of an opinion under section 169 or 170 CRPC, as the case may be, and forwarding a police report under section 173 CRPC. Thus, it is quite possible, my lord, may kindly mark, thus it is quite possible that more than one piece of information be given to the police officer in charge of the police station in respect of the same incident involving one or more than one cognizable offences. In such a case, he need not enter each piece of information in the diary. All other information given orally or in writing after the commencement of the investigation into the facts mentioned in the first information report will be statements falling under section 162 CRPC. 21, my lord, is very important. In such a case, the court has to examine the facts and circumstances giving rise to both the FIRs, and the test of sameness is to be applied to find out whether both the FIRs relate to the same incident in respect of the same occurrence or are in regard to the incidents which are two or more parts of the same transaction. That is why, my lord, we have shown the RFP, my lord. If the answer is in affirmative, is in the affirmative, the second FIR is liable to be quashed. However, in case the contrary is proved, where the version in the second FIR is different and they are in respect of the two different incidents crime, the second FIR is permissible. In case in respect of the same incident, the accused in the first FIR comes forward with a different version or counterclaim, investigation on both the FIRs has to be concluded. This is so far as counterclaim is concerned. And my lord, the next judgment, my lord, is Anju Chaudhary. I think that was also placed earlier. 2013 6 SCC 384. Did you?
Anju Chaudhary, one second, let me check.
Like my lord. 2013 6 SCC 384.
No, that is not there.
Well, I have handed over my. Page 399 at para 14 month. Anju Chaudhary. Para 14, your lordship got it. On the plain construction of the language and scheme of section 154, 156 and 190 of the code, it cannot be construed or suggested that there can be more than one FIR about an occurrence. However, the opening words of section 154 suggest that every information relating to commission of a cognizable offense shall be reduced into writing by the officer in charge of a police station. This implies that there has to be the first information report about an incident which constitutes a cognizable offense. The purpose of the purpose of registering an FIR is to set the machinery of criminal investigation into motion, which culminates with filing of the police reports in terms of section 173(2) of the code. It will thus be appropriate to follow the settled principle that there cannot be two FIRs registered for the same offense. However, where the incident is separate, offenses are similar or different, or even where the subsequent crime is of such magnitude that it does not fall within the ambit and scope of the FIR recorded first, then a second FIR could be registered. The most important aspect is to examine the inbuilt safeguards provided by the legislature in the very language of section 144 of the code. These safeguards can be safely deduced from the principle akin to double jeopardy, rule of fair investigation, and further to prevent abuse of power by the investigating authority of the police. Therefore, second FIR for the same incident cannot be registered. Of course, the investigating agency has no determinative right. It is only a right to investigate in accordance with the provisions of the code. The filing of report upon completion of investigation, either for cancellation or alleging commission of an offense, is a matter which, once filed before the court of competent jurisdiction, attains a kind of finality as far as police is concerned, may be in a given case subject to the right of further investigation. But wherever the investigation has been completed and a person is found to be prima facie guilty of committing an offense or otherwise, re-examination by the investigating agency on its own should not be permitted merely by registering another FIR with regard to the same offense. If such protection is not given to a suspect, then possibility of abuse of investigating powers by the police cannot be ruled out. It is with this intention in mind that such interpretation should be given to section 154 of the code, as it would not only further the object of law, but even that of just and fair investigation. More so, in the backdrop of the settled canons of the criminal jurisprudence, reinvestigation or de novo investigation is beyond the competence of not only the investigating agency, but even that the learned magistrate. The courts have taken this view primarily for the reason that it would be opposed to the scheme of the code, and more particularly section 167(2) of the code. Now 15, it has to be examined on the merits of each case whether a subsequently registered FIR is a second FIR about the same incident or offense, or is based upon distinct and different facts, and whether its scope of inquiry is entirely different or not. So, my lord, scope of inquiry has also been taken into consideration. It will not be appropriate for the court to lay down one straitjacket formula uniformly applicable to all cases. This will always be a mixed question of law and facts depending upon the merits of a given case. My lord, next para 27, my lord. 25. I'm sorry, my lord, page 406, para 25. At the bottom, my lord, page 406. The first information report is a very important document. Besides that, it sets the machinery of criminal law in motion. It is a very material document on which the entire case of the prosecution is built. Upon registration of the FIR, beginning of investigation in a case, collection of evidence during investigation, and formation of the final opinion is the sequence which results in filing of a report under 173 of the code. The possibility that more than one piece of information, the possibility that more than one piece of information is given to the police officer in charge of a police station in respect of the same incident involving one or more than one cognizable offenses cannot be ruled out. Same that has happened in my case, my lord. Other materials and information given to or received otherwise by the investigating officer would be statements covered under 162 of the code. The court, in order to examine the impact of one or more FIRs, has to rationalize the facts and circumstances of each case and then apply the test of sameness to find out whether both FIRs relate to the same incident and to the same occurrence, are in regard to the incidents which are two or more parts of the same transaction, or relate completely to two distinct occurrences. If the answer falls in the first category, the second FIR may be liable to be quashed. However, in case the contrary is proved, whether the version of the second FIR is different and they are in respect of two different incidents / crimes, the second FIR is permissible. This is the view expressed by the court in Babu Bhai versus State of Gujarat. This judgment clearly spells out the distinction between two FIRs relating to the same incident and the two FIRs relating to different incidents or occurrence of the same incident. And this is the test to be applied so far as the facts of the case are concerned, my lord. That is why we have brought the RFP and the LOI. Well, the next judgment, which, well, these are the three judgments which have been thoroughly relied in all subsequent cases, my lord. And I will place one last judgment of 2026 that is squarely covering my case. 2000 Amit Katyal. Amit Katyal, last of the 2026 SCC online SC 890. Amit Katyal versus State of Haryana. দুটা দি দিয়া, হ্যাঁ, দুটা আছে না? দুটা আছে? At a 890 at a 1051. Madam, may kindly have 2026 SCC online SC 890. Madam, has it? 2026 SCC online SC what 890. 890.
These are two different cases or what?
No, my lord, this is the same case, but subsequently there is one more miscellaneous application so far as to which police station the subsequent FIRs will be transferred. That is the second order, my lord, 1051. I will place that later on, my lord. It is also connected in my case. My lord, may kindly have 890 first. 2026 SCC online SC 890 decided on 18th May 2026. Paragraph 1. The present writ petition filed under Article 32 of the Constitution of India has been instituted by the petitioners seeking appropriate directions from this court for clubbing / transfer of multiple first information reports registered against them in different jurisdictions arising out of the same set of transactions pertaining to the real estate project Brahma City Krish World, so as to obviate multiplicity of proceedings and to enable the petitioners to effectively defend themselves in the criminal proceedings. Now, this is the scope. Let me kindly next turn to paragraph 4. Third page, paragraph 4. However, some other aggrieved victims chose to lodge FIRs at Haryana on almost the same allegations of not delivering the plots and of misappropriating the money paid by home buyers investors by the petitioners. Two FIRs, FIR number 221/2013, PS Sector 5556 Gurgaon and FIR 674 PS Gurgaon Sadar were registered against the accused company and its directors at Gurugram in respect of the said project. The petitioner and the concerned accused company, however, showing their bona fide, settled the matters with a few home buyers and refunded the amount consequently, and the said FIRs were quashed. Well, earlier the background is at paragraph 3. There are multiple FIRs registered in Delhi by EOW. I missed that, my lord. At paragraph 3, there is a chart. Paragraph 3, all these multiple FIRs were registered by EOW Delhi, same in agency. And subsequent FIRs, my lord, came to be registered at Haryana by different agencies. My lord, next at paragraph 15, my lord, contentions. Paragraph 15. Learned senior counsel for the petitioners contended that several FIRs have been registered in Delhi, EOW and Haryana based on the same real estate project Brahma City / Krish World, FIR number 30/2019, EOW Delhi, already clubbed complaints of 83 home buyers and is under investigation / trial. Earlier round also, my lord, there was a litigation and thereafter subsequently all FIRs were clubbed together. Subsequent FIR number 439/24, Gurugram, is based on identical allegations such as cheating, non-delivery of the plot of / flats to the respective home buyers, siphoning of the amount paid by the home buyers / transferring the said amount to the other companies and or diverting the amounts to other projects. My lord, next paragraph 16. Learned counsel further submitted that lodgement of multiple FIRs at different places causes serious prejudice to the petitioners and the same would amount to an act of double jeopardy against the petitioners, and there would be a consistent hanging sword of coercive action against the petitioners, namely affecting his arrest. Now, paragraph 17. Mr. S.V. Raju, learned ASD representing the state of Haryana, while opposing the petition submits that there are serious allegations against the petitioners. The scope of alleged misdeeds by the petitioner is not limited only to one state, but the offences are committed in different states. Petitioners have cheated a large number of innocent home buyers who have invested their entire earnings in these projects with the hope of shelter. Considering the nature and scope of offences, the investigating agency will have to undertake an exercise of thorough investigation. Considering the accusations against the petitioners of siphoning the amount and transferring the amount in the other projects, the investigating agency will have to unearth the trail of money. Considering the serious allegations against the petitioners, the Haryana State Police constituted the special investigation team, and the same has carried out the extensive investigation. But here there are different states involved. Here there are different districts involved. At para 21, TT Anthony has been referred, which I have already placed, para 18. And my lord, para 22, further case of Arnab Goswami, Amish Devgan and Mohammad Zubair was referred. I'm not troubling your lordship with, because it has followed TT Anthony, Babu Bhai and what was the Anju Chaudhary. My lord, next para 23, conclusion. The material produced before us show that though the FIRs were registered at various places, that is, some in Delhi and some in Haryana, a common thread in the nature of grievances raised by the complainants, who are primarily home buyers, that in spite of an assurance given by the petitioner and money accepted by the petitioner, the petitioners fail to hand over the possession of flats to the respective home buyers. In so far as the allegation in respect of transfer of money is concerned, it is only in the FIR complainant registered at Haryana, and as certain properties are situated in state of Haryana, the enforcement directorate entered in the scene. But leaving 1, 2, 3, 4, 5, 6 lines, my lord. There is also leaving 6 lines, my lord, from there. There is also some merit in the submissions of the learned senior counsel for the petitioner that the multiplicity of the offences registered at various places would cause some prejudice to the petitioner. My lord, this is very important, same which I have pleaded, my lord. It is submitted by Mr. Raju that considering the nature of allegations, the Haryana police constituted SIT and an extensive investigation is carried out by the Haryana police. Mrs. Bhatti submitted that Delhi police is having no objection in if the investigation is carried out by Haryana police. 24. In such a situation, the principle laid down in TT Anthony versus State of Kerala, as consistently reaffirmed in subsequent decisions of this court, squarely applies, inasmuch as there cannot be multiple FIRs in respect of the same occurrence or transaction giving rise to cognizable offences. The scheme of the Code of Criminal Procedure postulates a single comprehensive investigation with liberty to the investigating agency to conduct further investigation and file supplementary reports rather than permitting parallel and overlapping investigation in different fora. Permitting multiple FIRs and investigations in different jurisdictions on the same set of facts would not only be contrary to the settled legal position, but would also result in avoidable multiplicity of proceedings, conflicting findings, my lord, may kindly mark, and serious prejudice to the petitioners. At the same time, consolidation of such FIRs at one place would subserve the ends of justice by ensuring a coordinated, effective, and complete investigation, while also safeguarding the right of the petitioners to mount an effective and meaningful defense in a singular proceedings. This court is of the considered opinion that the subsequent FIR bearing 439 registered at police station sector 65 Gurugram, Haryana, arises out of the same set of allegations and forms part of the same transaction, which is already the subject matter of FIR in 30/29, registered at the Economic Offence Wing, Delhi. Permitting parallel investigations in such circumstances would not only be contrary to the scheme of the Code of Criminal Procedure, but would also result in manifest prejudice to the petitioners and multiplicity of proceedings. Accordingly, prayer A deserves to be allowed and is directed that FIR 30 PS Economic Offence Wing, Delhi shall stand transferred and clubbed with FIR 439 Gurugram, Haryana, to be investigated in accordance with law. My lord, subsequently, my lord, there was a miscellaneous application which was filed in this case, so far as to which police station the FIRs needs to be transferred. And the Supreme Court has held that the initial FIR where it was lost, subsequent FIRs needs to be transferred in the first FIR, with the first FIR. My lord, may kindly have,
in your case, it will be disproved.
in my case, it will be disproved, because that is the first FIR which is dated 13/9/2000. My lord is having 1051. Paragraph 3, my lord. This court, while passing the judgment and order dated 18/5, has observed in para 26 that FIR bearing 439 at Gurugram, Haryana arises out of the same set of allegations and forms part of the same transaction, which is already the subject matter of FIR 30 registered in the EOW, Delhi, and therefore permitting parallel investigation is not proper. Now, my lord, leaving 4 and 5, 6.
But in para 27, it was decided that it will be clubbed with the.
My lord, but earlier EOW was transferred, clubbed with Haryana. Now here, by this miscellaneous application, Haryana has been clubbed with EOW, because that is the law. The first FIR will hold the field, not the subsequent FIR. My lord, may kindly have para 6 once. The relief granted, my lord, has it?
Yes.
The relief granted has to be in consonance with the reasoning contained in the body of the judgment, and as such, we are of the opinion that the relief portion of the judgment and the order dated 18/5 requires to be corrected/modified, and instead of directing FIR 30 PS Economic Offence Wing, Delhi be clubbed and transferred to FIR 439 Sector 65 Gurugram, Haryana, and FIR 439 Haryana ought to be clubbed and transferred to FIR 30 EOW, Delhi. Sri Raju has resisted the proposed modification, contending that the accused cannot be permitted to choose the agency, investigating agency. 8. The clarification/modification application is not seeking any relief so as to select the investigating agency. The investigation in the offence is being carried at 2 places, and the court has directed clubbing of investigation. However, after clubbing the investigation in respect of the FIR, earlier in point of time, had been directed to be transferred to the place of subsequent FIR, which is not in accordance with the reasoning contained in the judgment. Therefore, it is simply a clarification modification in the order so that the subsequent investigation may be clubbed with the previous FIR and the investigation in connection thereto in terms of the recital in the judgment. We are informed that there is no stay on investigation in FIR 30. Accordingly, it is directed FIR 439 be clubbed and transferred to FIR 30 of EOW, Delhi. And my lord, only a brief reference to my second additional affid, only one page, my lord. It would be a minute. So far as to satisfy the test of sameness, my lord, page 34. For a moment, I will only take 30 seconds.
You are not referring to other cases, not Arnab Ranjan Goswami.
No, my lord, because these all follow these 3 cases, my lord. TT Anthony, Babu Bhai, and
Got it now.
yes, my lord.
What?
Anju Chaudhary. My lord, 234, my lord, once for a moment, my lord, 234, annexure 14. It was filed on 16/7/2024.
What? 234?
234, page 234, my lord. Additional affidavit, 234.
Yes.
My lord, this is the official correspondence, my lord. This is addressed to all assistant labor commissioners And this was by the Deputy Labour Commissioner of the board, my lord, which was concerned for directing the payments. With reference regarding payment to all benefits and stipend to trainees. All benefits would include, my lord, all expenditure towards the program. With reference to the subject cited above, you are aware that the payment of all benefits, including stipend to trainees undergoing skill development training under the board, are released through DBT mode and transferred to the accounts of the beneficiaries through PFMS portal. The process for release of stipend involves validated list duly verified and checked by you and cross-checked by with the biometrics of each and every trainee. All benefits, including stipends, are released with the approval of the authority. Further, as it is made through bank directly, there might be some delay for non-payment related to disbursement of the benefits, including stipend for various genuine banking issues like invalid account details, inactive account number, etc. It is observed that very often workers are aggrieved due to delay and or for not receiving payment, which arises due to lack of awareness on the disbursement process. It is felt that the issue requires urgent intervention from your end to educate the beneficiaries on regular basis during orientation, awareness meeting, district scrutiny meetings, etc. regarding the process involved, and to assure them the benefits due to them will be disbursed and request them to bear with this office for the genuine delay in the process involving bank requirements. So the scheme, my lord, was never routed. The money was never routed through the training provider.
What is the purpose of showing this?
My lord, why I'm showing my way so far as to satisfy the test of sameness, my lord. All benefits which was routed to the was paid to the beneficiaries was made through direct bank transfer by the department. This is the single transaction, my lord. The benefits which they are agitated about, that we have not received stipend, they have not paid us this allowance. Now this scheme, my lord, was designed as such that the beneficiaries will be paid directly by the government. It is not routed through the training provider. So therefore, my lord, all payments which were made during the after verification of the biometrics, my lord, all payments which were made to the beneficiaries were made directly by the department to the beneficiaries in their respective bank accounts. The payment was never routed through the service provider, my lord. Had it been a case, my lord, that
is on merits. That is nothing that
my lord, so far as the test of sameness is concerned, my lord, why I am pressing this document, my lord? Because after all, my lord, the entire allegation is regarding non-payment of the dues. And the payment, my lord, was
for the purpose of sameness, you are showing it. That's fine. That's fine.
Yes, my lord.
Otherwise, we need not go with
Yes, yes, my lord. On merits, my lord, I am not on merits, my lord. Only for the purpose of sameness, my lord. That the entire transaction is managed by the labor department, my lord.
Yes, yes. You conclude. You conclude. You have anything to say, Mr.
I have lots of. I'll take 2 minutes, my lord. But the decisions relied by my learned friend, my lord.
So if you take some time, then we'll keep it some other day.
Lots of. I'll take 10 minutes time. I have
Take some time. You have to distinguish those cases.
Yes, my lord.
Then we can take it up on day after tomorrow.
Day after tomorrow.
Huh? Day after tomorrow at 2 o'clock we'll take it up.
Lot.
Heard Mr. S. Das, the learned counsel, referring to the accused applicant. There is also heard. Mr. Dina, the learned senior officer already referred hearing remain inconclusive. Let the matter be listed on day after tomorrow. That is on 11.
My lord, the last judgment I have placed, my lord, this is our High Court, my lord, which has followed all those 3 judgments, my lord.
এটা পাবো।
Very difficult.